हेलो। हेलो चेक। हेलो चेक। उनको आ रही है। ठीक है, ओके।
that I extend warm welcome to our prestigious today distinguished speaker series at our university. On behalf of Rajiv Gandhi National University of Punjab, I am delighted to host such an esteemed gathering that brings together thought leaders from the corporate and legal sectors to engage in insightful discourse and knowledge exchange. Rajiv Gandhi University of Law, Punjab has established itself as a premier legal institution, consistently producing top-tier legal professionals. The university boasts an impressive placement record with graduates securing position at leading law firms such as AZB and Partners, Sardul, Amarchand Mangaldas and Company, Trigil and Khetan and Company, Arjun Illuminati have also excelled in academia, the judiciary and corporate legal sector. As it is said, Vidya Dadat Vinayam, knowledge gives you humility. In the spirit of continuous learning and professional growth, we gather to engage with distinguished leaders from the corporate sector, litigation, and other respected legal professionals. We are truly honored to have us today and tomorrow a distinguished panel of fellow luminaries who have carved out remarkable paths in their respective fields. Their presence here is a testament to their commitment to sharing their invaluable insight and experience with our university community. Today we have the pleasure of hosting Honorable Mr. Justice Sabiul Hussain, former Judge Allahabad High Court and Chairperson of the Punjab PIT and DPS Board, NSA, and CEO अभी क्या है? कोफा चंडीगढ़. Dr. Devan Judge, Mr. Arpinder Singh Grewal, Judge of Punjab and Haryana High Court, all consented, but due to he has given consent, but due to some problems, he could not join our event. I also thank to him. Mr. Rajiv Rambathala, partner at Luthra and Luthra Law Offices, India, and a visionary leader in commercial litigation, consumer litigation, arbitration, company law, and regulatory issues. Mr. Karthik Jain, partner at JSA and seasoned expert in MLA and PEBC, corporate, commercial, and white-collar crimes and investigations. Ms. Surbhi Mehta, co-founder and partner at Adhrid Legal and a renowned strategist in intellectual property, competition law, trade, TMT, regulatory and policy practice. Mr. Astha Rehan, co-founder and partner at Imadan Law Officer and pioneering innovator in real estate, infrastructure, contract and joint venture transaction. Mr. Vineet Rehan, founder and managing partner at Adyant Legal and a pioneer innovator in insolvency law, arbitration, domestic and international, corporate, commercial matters, intellectual property law, banking law. Ms. Kaustubh Sinha, co-founder and partner at Adhrit Legal and renowned strategist in corporate, commercial and dispute resolution practice. Their insight into the corporate litigation and judicial world will undoubtedly enrich our understanding and inspire our leaders to explore technology. Their presence here is fostering a deeper understanding of legal practice. The exemplary track of our speakers in their respective careers embody this philosophy of excellence, and we are deeply grateful for the opportunity to bring insight from their remarkable expertise and experience. Your presence here is a testament to our commitment to nurturing the next generation of leaders. I am confident that your reflection will not only educate but also our students to strive for excellence. Events like these are beautiful in bridging up the gap between academia and industry, providing our students with real world perspectives that are invaluable to their professional journey. To our students, I encourage you to engage fully and our guests, ask questions and seek advice. This is a rare opportunity to learn from the best in this industry and legal fraternity. Remember, the connections you make here you can shape your future in profound ways. Before concluding, I wish to acknowledge the meticulous effort of our faculty and students as an extension of the administration silo who have orchestrated this event with exceptional intelligence. This commitment to enhancing our educational discipline warrant our collective recognition. With these words, I humbly inaugurate our distinguished faculty. I say today after eliminating this quoted intellectually stimulating excellence and inspirational narrative that undoubtedly contribute significantly to our collective scholarly advancement. Thank you once again for your participation. May this good with enriching controversy and valuable insight. Welcome and let us comment this symposium with William and Parvat. Namaskar. Thank you.
Thank you for your inspiring words, sir. I would now like to request Mr. Karthik Jain to address the audience.
Uh, Good morning, everyone. First of all, I would like to thank the university to give me this opportunity to come here and interact with all of you on some of the topics which are quite relevant in today's time. And it was an honor to meet the esteemed judges this morning, and we had a very good conversation. And I look forward to interacting with all of you throughout the day, and also to understand your perspective of how you perceive this field, particularly from the corporate and M&A side of the world. For last 17 years, I have spent days and nights practicing the corporate M&A law, and I would be happy to give the answers to whatever knowledge I have or experience I gained in last 17 years, and try to resolve or throw some light on the questions that you may have, regarding this field. So look forward to a fruitful day, and spending the time with you guys. Thank you.
Thank you for your words, sir. We look forward to hearing from you more later. Now I request Professor Dr. Satish Chandra to address the audience.
Good morning to all friends. I am highly thankful to Honorable Justice Naik, also Professor Shankar Singh, and I am also grateful to him that he endeavored to install me in this university, which is a privilege for me. Before this, I retired from University of Allahabad in 2020. So you can just understand, you are the future and I was the past. Rather, I am the past. So past is communicating with the future. As far as the future of corporate law is concerned, it is really a future. It has grown, ever growing, and it shall remain to be grown. Now we were discussing informally in the chamber the advent of AI along with this corporate dimensions of the corporate. We belong to such a generation where we were deficient of all these things: computer, laptop, online. So unfortunately, we were realizing very late that all these developments are boon for the humanity. Humanity, I am talking humanity. Humanity means students, teachers, academicians, litigants, readers, and other sectors of the society. So I can't imagine. But I can only bless you that you go forward in this field, because I have the remotest of the knowledge. There's a novel of, there's so many novels in the past which I have read. There was a Godana Premchand, which made aware us about your society. But it is very fortunate on your part, it is fortunate in your time that you are very blessed with the acquaintance of those knowledge of the societies which we had not. We had no system of approach, system of corporate approach, even not physical transport and approach. So I wish you all, and I thank you, so that I have got an opportunity to convey before you something, but unfortunately, I am in least position to deliver you about your future, which is really your future. It should be your future. Thank you.
Thank you for your words, sir. Now we have with us here today Surbhi Mehta, ma'am, co-founder and partner at Adhrit Regal. He heads their intellectual property, competition, trade, TMT, regulatory and policy practice, and has consulted various key clients. As I mentioned earlier, she's also contributed to various research initiatives as part of her association with the International Bar Association. I request our faculty coordinator, Dr. Saurav Kumar, along with our Vice Chancellor, to present our token of gratitude to ma'am. Ma'am, I request you to briefly address the audience.
Hello, good morning. My name is Surbhi Mehta and I'm a lawyer. I'm a lawyer for the last 20 years. I know it sounds like a very long time, but the time just passes. I just remember actually coming to Patiala, I was getting very nostalgic because I'm the second batch of Army Institute of Law, and our temporary campus used to be in Patiala from 2000 to 2003. And the moment the invitation came, I said I have to go to Patiala to relive the entire thing. And since yesterday, we've just been exploring places and figuring out, oh, Gopal's is there, oh, that one is there. So yes, we've had a long night, but I'm very, very happy to be here addressing a very important topic. And I look forward to it. All the very best. Thank you.
Thank you, ma'am. All of us look forward to hearing from you in a bit. Now I would like to request Honorable Justice Shabihul Hasnain to take the dais and address the audience.
Honorable Vice Chancellor, Dr. Satish Chandra, other faculty of this college, and of course, dear students, if you have ever seen a court, there is a cause list. That number of cases are there, hundreds, sometimes 80, sometimes 120. And then if your number is 86, you just relax that it will come after lunch. But suddenly, the cause list collapses. So I was thinking that it is an inaugural session and my chance will come after 12 or something. But the list has collapsed like anything. So out of turn, I'm here and without a brief. I come from Lucknow. And Lucknow is in UP, that you must be knowing. Allahabad High Court, the biggest High Court of India. And I belong to Allahabad and I practiced at Lucknow. तो उसको हिंदी में हम कहते हैं कि मेरी जन्मभूमि लखनऊ इलाहाबाद थी और मेरी कर्म भूमि लखनऊ थी. तो I bring greetings from Allahabad as well as from Lucknow. And that greeting from Allahabad has been tripled because the Vice Chancellor and Dr. Satish Chandra also are from Allahabad. Before I start something on this subject, I would like to ask you a question. Today's subject is the future of corporate laws. Of course, you have been studying corporate law here and you are so techno-savvy. Everything which I am likely to tell you, you already know because you have a computer and you have a Google, which is related to all of us. He is the uncle Google. सबके uncle है वही हैं, वो सबको बताते हैं वो. तो would you like me to talk about this subject or should I share something which you do not know? Because the current and the present is better understood by this generation rather than the people from the old school. As Dr. Satish Chandra he gave me a food for thought that what were the conditions when we were as students, how we coped with the studies, and what has been, God has been kind to give it to you. Perhaps someone from the past should come and tell you that whatever you have got on the platter was not available for this country for a very long time. And because of the resources, the infrastructure, and the focus on the subject of law, law was facing real bad days. And then we had very, very bright lawyers, philosophers, who thought that law needs to be revamped, repackaged, renovated, and researched and put in a better pedestal so that you all can benefit from that and ultimately the country benefits and the people of the country benefit from this knowledge. And this is how the national law universities, the concept of national law university around 86 or something, that came into existence, and then spate of law universities are there and they are doing very, very well. And you are the cream of the society. You are the best of the students who have competed, and you are given this opportunity to enhance your career or enhance your knowledge through the national law universities. You have a beautiful campus. I have seen a bit of it only. But will you like to know how the law was, or do you want me to speak how the law is? Anybody for the past? Nobody. Nobody wants to know. Come on, listen. Have you? How many of you have seen a court? Actually, not a moot court. You've seen, all of you. Very good. Very good. Have you seen the lawyers walking there and they wear a gown. All of you have seen that. Have you ever seen a senior advocate wearing a gown and something of a kind of a triangle is hanging at the back of that gown? How many of you do know that why is there that it's a embroidery है कोई या क्यों एक गाउन बड़ा अच्छा सा है सिल्क गाउन भी होता है कभी कभी अब तो नहीं होता वैसे कॉटन का गाउन होता है लेकिन उसके पीछे एक लगा रहता है टैग सा पाउच कहते हैं उसे ever thought of it why this a very handsome young dynamic corporate lawyer or any lawyer or a senior advocate walking into the court wearing a gown and a coat and still has a baggage at the back. Okay, perhaps nobody has consulted this on Google. Perhaps Google will also not be giving you the correct or the emotional response. You are all called advocates now, lawyers, counselors. Earlier, originally the word came as pleader. The original word was pleader. And who was a pleader? One who pleads. आज भी आप pleading ही कहते हैं अपनी आप चीज को. The person who would plead on behalf of anybody else was a pleader. And why was he required? Suppose I have a case. I'm the best person to raise my grievance. How does pleader come into being? Pleader was engaged or invited or requested to plead on behalf of XYZ because XYZ was an aggrieved person but did not have the gift of the gab, did not have the acumen or the study to present his case, to make out a case. Maybe he was too shy. He did not have good words, but he was aggrieved. So an intelligent person of the society, any person who was more intelligent, more vocal, more understanding, knowing a little law or more law or common sense, always came forward. Okay, don't worry if you are aggrieved, you have been wronged. There is a judge, a magistrate, or anything, a king. We have all inherited, all these laws have come from England, so king also comes as a judge. Oh, he used to come and plead on his behalf. And he was a pleader. But since he was doing it for helping a person who was in distress, so he did not ever thought of asking for money for this service. And that is why it has always been considered to be a noble profession. जब मैं वकालत में आया तो चीफ जस्टिस ने मुझे कहा कि वेलकम टू द नोबल प्रोफेशन. आई एम टॉकिंग ऑफ 82. So what happened? Then more and more people started getting to that man. मेरा भी केस कर दो, मेरा भी बात बता दो, मेरी जमीन इसने कर ली है, ये मेरे इसने मुझे मारा है, type of things. And that man became so engaged that his livelihood started suffering. He was also aggrieved. but what to do? The human society was such, with so many values, of human values, that he could refuse if anybody would said that, Mera kaam kar do. The society realized that here is a good man who is working for us and is too honest, humble, and God-fearing and benevolent to ask for money. So they started putting some coins behind his back in the gown, which a cloak was there, which had many pockets. आंख, थोड़ी सी हिंदी समझ लेंगे ना? आंख में आंख डालकर वो प्लीडर अपने क्लाइंट से पैसा लेना शर्मिंदगी समझता था. एक नेकी का काम कर रहा हूं, इसके लिए पैसे ले लूं. लेकिन समाज अपना दायित्व समझ के उसके क्लोक में पीछे कुछ कॉइन डाल देते थे कि तुम्हारा खर्चा भी तो चले. उसी की निशानी के तौर से पीछे वो एक रेलिक है, which is known as money bag also sometimes. लेकिन अब चूंकि हम आंख में हाथ डाल के और क्लेम करके फीस लेते हैं और डांट के भी लेते हैं और नहीं होता तो हम कोर्ट में जाते भी नहीं हैं, इसलिए शायद वो गाउन में से हट जाना चाहिए. But it's still there to remind you about the noble profession of which you are the next generation. So you come from a very, very proud kind of heritage and human values. You may go for corporate laws, that is the need of the hour. You may use AI, you may use Google, you may use Manupatra, SCC, and whatnot, which is being given to you. But remember that you have a legacy. आप बहुत महान प्रोफेशन में हैं. Please, for God's sake, don't think that you are in a business field. आप बिजनेस जरूर कर, बिजनेस तो वर्ड गलत हो जाएगा, but don't keep it in mind that you have come here only to make your career and to earn a lot. वो तो आपके साथ का पड़ोस में जो बिजनेस वाला है, जिसकी ज्वेलरी की दुकान है, वो भी कर रहा है. But you coming from NLU, Law University, National Law University, as a lawyer, as an advocate, who had his origin in the pleader. And for whom? And who has given you this law university? This country. And what is this country? What is this country? This country is we, the people of India, having solemnly resolved to constitute India into a sovereign but socialist. So long the constitution is there, it's a socialist country. And every one of you, including myself, have a social responsibility. And that will make you proud when you connect yourself with the people of India. And owe it and feel that we owe it to the people of India who are looking at you with hope that the legal system will be such which will be accessible to them also. If you have a system which is accessible only to few, will it be in consonance with the Constitution, with the preamble, for the people, by the people, of the people? So I thought that since the teachers who are very heavily burdened with the syllabus, and you are too worried for your exams, and everything is so fast paced that you will not have time, and the teachers will also not have time to remind you of your great heritage and legacy and your social responsibilities apart from the laws. I will talk about corporate. Sir, have I run out of time? Or I have the whole day because your list has collapsed. So I'll take a very few time, don't worry. Because I was a judge, and after a little while I used to get impatient. यार काम बताओ, अपना बताओ ना, point बताओ, भाषण क्यों दे रहे हो? I'll also not give you a little bhashan. It's a big bhashan, but bit of it. मैं आपको थोड़ा सा अपना introduction भी दे देता हूँ. Not that I'm going to contest any election in NLU, but to tell you why you should believe in me. Of course, I had my LLB, so वहाँ तक तो हम आप बराबर ही हैं. I started my practice in 83, 82 में pass out हुआ था. And इलाहाबाद हाई कोर्ट, लखनऊ हाई कोर्ट में मैंने शुरू किया. So I put into about 24 years of practice, legal practice. And during this period, I contested 5 elections in the bar. And it is a record that I won all 5. उसमें देखना गूगल में करके शायद होगा कहीं, और नहीं होगा तो इलाहाबाद लखनऊ यूनिवर्सिटी, लखनऊ हाई कोर्ट से पूछ लेना. Why I am saying this? And then I was a standing counsel for the state of UP for 12 years and 14 years for Union of India. And then I was elevated as a judge, and I was there for 12 years. I am giving this introduction not because I need you to know and put a photograph of mine, but to tell you that you are getting whatever I'm saying from a well-informed person who has seen all sides, all shades of a lawyer. I have seen lawyers in abject poverty. I have seen lawyers carrying their files on a rickshaw or on a cycle, coming to the court, putting it somewhere, going under a tree, putting up a gown. District courts में यूपी के बार के लिए बहुत ऑफिसेज नहीं होते हैं. वो मैदान में तखत डाल लेते हैं, उसी पे एक डिब्बा ला के रख देते हैं, उसी के अंदर उनका बस्ता होता है, उसको बस्ता कहते हैं. क्लाइंट आता है, उसी पे बैठता है, वहीं पे उससे जो भी हो सकता है वो नोच खसोट होती है, और फिर उसका केस होता है, और दे गो देयर. और उसके बाद भी हमारा लीगल सिस्टम बहुत रोबस्ट है. जुडिशरी has done a lot of proud, except for some few exceptions, always there. But judiciary has given marvelous judgments which are read all over the world despite this disparity. I am telling you all this only that to sensitize you that apart from this beautiful campus, beyond this, not apart from, but beyond this campus, there is a huge country. And there are people who are looking up to you. इसमें से कोई मेरा भी केस करेगा कभी. There are litigation, thousands of cases. Every day you read that there was so much of delay in justice. There is so much of number of cases are pending in Allahabad High Court and criminal appeals. Can you imagine? 32 years के बाद criminal appeal आई मेरे पास. 32 years. He could have been acquitted earlier if the petition was heard. In that case, the convict had died. So I had an easy out. अबेट कर गए, पिटीशन खत्म हो गया. But just imagine 32 years के बाद फाइनल हियरिंग पे आई मेरे सामने. These hard realities of our country and the people who expect a better deal, they are also looking up to you. I'm just sensitizing you. I'm not telling you to leave your lucrative corporate law and get a law firm, get into that, get into package, because you invest a lot, and the company law is the need of the hour after this globalization. The whole global world has come shrinked. So you are needed there also. But I beseech you to think in terms of proper litigation in the courts. Sometimes think of going to a small court also. Visit a civil court in a district and see a Lok Adalat practically. Go into a small district and see what is happening. You are very lucky that you are sitting in air-conditioned rooms. You are getting all the books and the best of teachers and the speakers who have come from Delhi. They are very much necessary for the society and for the people. But simple knowledge, there is a small saying that knowledge is proud that it knows so much. Wisdom is humble that it knows no more. So whatever you are getting through internet and those technology, that is knowledge. Life will give you wisdom. Live your life as an Indian. And being an Indian means to know your India, know the country, know the people who have sacrificed themselves to give you the freedom to a free state. They very, very painstakingly brought out the Constitution. If you have ever seen, and I will recommend very strongly, and I will request the Vice Chancellor also, there was a serial, संविधान राज्यसभा टीवी ने बनाया था, जिसमें कॉन्स्टिट्यूशनल डिबेट्स हैं, जिसमें जब संविधान बन रहा था तो complete, because reading it's very bulky, but you will see that every article was debated so much. It has not come out of magic. The aspirations of the people of India. For 3 years, the Constituent Assembly debated and debated and debated. If you just see those debates, you will have this feeling कि कितने मुश्किल से आपके पास ये संविधान आया है, कितने मुश्किल से आपको ये सब कुछ मिला है. Do you think that you have to give back to the society, or you have to give it back only to yourself? आज मैं यहाँ पे खड़ा हूँ, मुझको टीचर्स ने, सतीश चंद्रा साहब जैसे, वाइस चांसलर साहब जैसे लोगों ने, जो उस समय मेरे गुरु थे, उन्होंने मुझे पढ़ाया होगा, आज वो कहीं और होंगे. मेरे साथ जो छोटी सी लाइब्रेरी यूनिवर्सिटी में थी, उसमें लाइब्रेरियन ने मुझे बुक्स लेड की थी. मेरे फ्रेंड्स ने कभी मुझे अपने मोटरसाइकिल पर पहुंचा के स्कूल तक कॉलेज तक, यूनिवर्सिटी तक पहुंचाया, जहाँ पे क्लासेस होती ही नहीं थी. तब जाके हम लोग कहीं लॉयर होके आज यहाँ खड़े हैं. वो लाइब्रेरियन जिसने वो किताब मुझे लेंड की थी, उसको क्या उम्मीद नहीं होगी कि जिसको मैंने ये किताबें लेंड की थी वो बढ़ के बड़े आदमी होके जज हो गए तो हमारे यहाँ के जो लिटिगेशंस हैं उसमें न्याय करेंगे. Will it not be a legitimate expectation? It will be. So, I have not come here to depress you. I have come here, actually I had not come here for this. ये अभी डॉक्टर साहब से बात करते करते यहाँ पे जब उनके कमरे में बैठे हुए थे, तो ये बातें मुझे ध्यान में आई कि शायद नए बच्चों को अपने भारत के बारे में और भारतीयता के बारे में और उनके दायित्व के बारे में शायद पढ़ाने का अवसर नहीं होता है। तो मुझे लगा कि मैं आर्टिफिशियल इंटेलिजेंस के बारे में बात करूं, जिसके बारे में आप मुझसे ज्यादा जानते हैं, तो शायद फायदेमंद नहीं होगा। बट इफ आई शेयर समथिंग विच हैज नॉट बीन हर्ड बाय यू, तो शायद मेरा आना जस्टिफाइड हो जाएगा। सो दैट इज व्हाई आई हैव टेकन योर टाइम एंड आई विल एंड my boring speech with a small thing which is coming to my mind. Again, this is from भारतीय परंपरा से है। परोपकार समझते हैं? तो एक श्लोक है संस्कृत का, परोपकाराय वहन्ति नद्या। नदी जो बहती रहती है उसमें पानी बहता रहता है, सब पेड़ भी उसी से अपने फायदा उठाते हैं, सब लोग पानी भी उसी से पीते हैं, गाय भी पानी पीती है, जानवर भी पानी पीते हैं। परोपकाराय वहन्ति नद्या, परोपकाराय फलन्ति वृक्षा। पेड़ जो है जो उसमें फल देते हैं, जिसको सब खाते हैं, उसके नीचे कोई कैशियर नहीं होता कि 3 फल तुम खा के गए हो तो बेटा पैसा दो। पानी, नदी जो है तुमसे पैसा नहीं मांगती। परोपकाराय दुहन्ति गावा। गाय जो दूध देती है उसका ओनर तो पैसा लेता है, गाय पैसा नहीं मांगती। परोपकारार्थम इदम शरीरम। ईश्वर ने ये जो शरीर बनाया है, हम नदी नहीं हैं, हम पेड़ नहीं हैं, हम गाय नहीं हैं, हम इंसान हैं जो इन सबसे बड़े हैं। तो अगर वो तीनों चीजें परोपकार के लिए अपना सर्वस्व, नदी कभी नहीं रोकती अपने आप को, पानी कितना भी ले लो, डैम बनाकर रोक लो तभी नदी बहती है। एंड ह्यूमन बीइंग इज द बेस्ट ऑफ क्रिएशन ऑफ गॉड। तो क्या हमें अपने इस शरीर से या अपने इस ज्ञान से या अपने इस शिक्षा से किसी को कुछ देना चाहिए? दैट इज अ क्वेश्चन, आई लीव इट विद यू। थैंक यू वेरी मच।
Thank you for your inspiring words, sir. I'm sure that all the students here today will take your advice and work towards fulfilling their duties as lawyers and citizens of the country. I now request our faculty coordinator, Dr. Shiva Satish Sarda, to deliver the vote of thanks.
A very good morning to one and all present here. At the outset, I don't have a privilege to say that I am a lawyer or I had been a lawyer for so many years. But on the behalf of all the faculty members, I do have a privilege, at least the ones who started teaching in 2009, that I have taught around 1,842 lawyers across India. And Honorable Justice Shabul Hassan, former Judge Allahabad High Court, Chairperson of Advisory Board, Punjab, for prevention of illicit traffic in NDPS, NSA, Coffee Posa, respected Vice Chancellor, Sir, Mr. Karthik Jain, Mr. Rajiv Rambhatla, Madam Surbhi, Astha and Vineet Rehan, and Kaustubh Sinha, Dean, Academics in Absentia, Registrar Ma'am in Absentia, my respected colleagues, other dignitaries of the dais, and my dear students. As we conclude the inaugural session of 2-day career conclave on the future of corporate laws, a conversation with legal luminaries, I would like to extend the vote of thanks on the behalf of Rajiv Gandhi National University of Law. Students, internships are crucial for a successful law career. providing practical experience, skill development, networking opportunities, and a competitive edge in the job market, bridging the gap between theory and practice. Currently, the dynamics of legal profession are changing like never before. See, time flew very fast. A mandatory 3 weeks or 2 weeks, I'm forgetting, Manoj sir, 3 weeks mandatory internship or 2 weeks mandatory code training per semester in 2009, when we studied law, metamorphosed into an assessment internship in 2019. Chambers turned to law firms, lawyers became associates, everyone settled and found their calling, and very few became teachers. Undoubtedly, everyone needs guidance, support, and encouragement to find one's calling and inspiration to take uncharted path. And I sincerely feel that there cannot be a better platform than this, which has been given to all of us by our respected Vice Chancellor, sir. Firstly, on the behalf of RGNUL, I thank Honorable Justice Shabiul Hasnan for delivering such a thought-provoking address. Your insights have inspired us all and set the tone for the discussions that will follow in this day. I also extend our heartfelt thanks to Mr. Karthik Jain, Mr. Rajiv Brahmbhatla, Madam Astha Trehan, Madam Surbhi, Kaustubh Sinha, and Mr. Karthik Jain. My students are very enthusiastic to learn and to listen to your engaging discussions. Your diverse perspectives will enrich their understanding of the complex legal issues. I sincerely thank our Vice Chancellor for his unwavering support in planning, coordinating, and executing this event. My heartfelt thanks to my faculty colleagues and co-coordinators, Dr. Manpreet Kaur, Dr. Jasmine, Dr. Saurabh Sharma, other faculty colleagues present here, Dr. Jaswinder, Dr. Manoj Sharma, Dr. Gurneet, Dr. Anubhav, Dr. Wazida, Dr. Aryan, for ensuring their august presence here. I would like to thank the media teams for covering this event extensively and allowing us to extend our hospitality. My sincere thanks to the organizing committee led by Akhilesha, Ekamjot, Aditya, Stuti, Sujatro, and everyone from the internship and placement cell, Aditi, Ujjara, Pranav, and my apologies for not being able to recall all the names, for their hard work and dedication in planning of this event. Your attention to the detail did not go unnoticed. This event would not have been possible without the support of university's IT branch, engineering branch, accounts, and photography team. Last but not the least, I thank all the student attendees for participating and making this event a vibrant platform for discussion. Thank you so much.
Thank you, ma'am. I request everyone present to rise for the national anthem. We'll begin the first session shortly after that. Internships are requested to come near the dais for a quick picture with all the guests. I request the audience members to stay seated. We'll start with the first session in a couple of minutes. Mr. Rajiv Brahmbhatla will be speaking shortly.
a wealth of experience spanning firm practice as well as in-house counsel role.
Sir will be joining us in a minute. Please remain seated till then, and we'll begin shortly.
This is Pragya Gupta here, along with my co-host Ishra Dhawan. It's my absolute pleasure to invite you to welcome you to this highly anticipated event, Forging a Path in Law, Conversation with the Luminaries. I extend a very warm and enthusiastic welcome to a distinguished guest, Mr. Ranjeev Rambhatla, who is joining us virtually. He's currently a partner at Lutheran Law Offices India, where he brings to the table a wealth of experience spanning firm practice as well as an in-house counsel role.
Sir, I hope we're clearly audible to you.
Yes, very much. Audible and visible. I hope I'm audible as well.
Yes, sir, you're perfectly audible. Thank you so much for joining us today. Sir has handled a wide range of matters, including commercial and consumer litigation, arbitration, company law, and regulatory issues. His depth of experience in dealing with complex high-stake disputes has made him a go-to counsel for several prominent Indian as well as multinational companies. Over the years, he has advised and represented industry giants like SpiceJet, Standard Chartered Bank, Ashok Leyland, Tata Motors, Aditya Birla Group, Jubilant Foodworks, and many more. From appearing before the High Court in high-profile litigation to representing major public oil and gas companies in arbitration proceedings, his contributions to the legal field are extensive and highly regarded.
His professional journey includes leadership roles, such as partner and head of the Hyderabad office at KSK and now at Lutheran Law Offices India. Earlier in his career, he also worked with Tempest Law Associates and began his legal journey with a strong foundation in both litigation and corporate matters. He has also served as in-house counsel for Toyota and Shrey Infrastructure Financial Limited.
And to top it all, Mr. Rambhatla was recently featured in the prestigious Chambers and Partners Asia Pacific 2025 rankings, an incredible achievement that stands a testament to his expertise and excellence in the legal field.
Today, Mr. Rambhatla will be speaking on a topic that is not only timely, but also transformative: the rise of institutional arbitration in India, a game changer for dispute resolution. Given his in-depth experience in arbitration and dispute resolution, we couldn't have asked for a more fitting speaker to guide us through this evolving landscape.
We are truly honored to have him here with us today, and I'm certain that his insights will be immensely valuable to all of us, especially to those who are looking to pursue a career in dispute resolution, arbitration, or corporate advisory. Without further ado, I invite Mr. Rampatla to address us. Sir, it's a privilege to have you here with us. Welcome. The floor is all yours.
Thank you so much for that wonderful introduction, and I feel very humbled to be here this morning. And at the outset, I'd like to apologize to everyone for not being there in person. I was looking forward to being there physically, but due to certain circumstances, I wasn't able to fulfill my visit this time. But I would look forward to being present in your campus sometime in the near future. Having said that, thank you once again for that wonderful introduction. As I said before, I am truly humbled, and I'm grateful that you have taken the time out to put together such a wonderful introduction about me. And thank you for that, and thank you for having me here. Good morning to everyone. It's an absolute pleasure to be here, albeit virtually, and it's really nice to see all of you. I can see the auditorium is full of enthusiastic students, and I'm guessing faculty members as well. I am very excited to be speaking to all of you on a topic that's very near and dear to my heart. That is arbitration, and of course institutional arbitration and its future in India. Before I talk about institutional arbitration and how that is the future and how its future looks in India, I would first briefly talk about a little bit about myself. Although our hosts have done a wonderful job of introducing me, I would like to give everyone a very brief introduction of myself from my side, and then of course talk about a little bit about arbitration and what I do in terms of arbitration, and then talk about arbitration in India and institutional arbitration as well. Before we go ahead, if I may just confirm, I hope I am audible and I'm clear.
Yes, sir, you're perfectly audible.
Perfect, great. Okay, so yeah, I think as you may already know, and thanks to the wonderful introduction already given, my name is Rajiv. I'm currently a partner with Luthra & Luthra Law Offices India. I handle the litigation, arbitration, and real estate practices here, based in the firm's office in Hyderabad. I'm primarily a litigator with experience handling litigation matters across various high courts in predominantly the South Indian states in Karnataka, Andhra Pradesh, Telangana, and Tamil Nadu. I also have significant expertise in appearing in insolvency matters before the NCLT benches and also the NCLAT bench as well in Chennai. And I also have handled quite a few arbitration matters, right from the application for appointment of arbitrator stage all the way to the completion of arbitration proceedings. And I've also handled the interim applications in certain arbitration matters as well before commercial courts and other courts, depending on the nature of the arbitration. My practice primarily has been on the litigation and arbitration side. I although started my career as an in-house counsel, as was rightly pointed out here, I started with a company called SREI, Shrey Equipment Finance, in Bangalore, way back in the early 2010s. This is a campus placement right out of law school, and I was excited to be an in-house counsel right out of law school, but quickly I realized that to be a good in-house counsel, it's important to be a good lawyer first, and for that I decided to come back to the grassroots of the practice or to a law firm, and to learn the insights of the law first before I become an in-house counsel. So with that in mind, I came back to a law firm called, or rather I joined a law firm for the first time called Tempest Law Associates in Hyderabad. I was with Tempest of the corporate team doing transactional corporate law for about 2 years. Then I moved back to Bangalore, was with another firm, and then was with Toyota Kirloskar Motor, again on the in-house side for about a year or so. And then had my own practice briefly, and then joined law firms. I was heading the Hyderabad office of a law firm called KSK, Kings Rakan Kasiva, before joining Luthra & Luthra last year in August. and I've been here ever since. So having been in Hyderabad, I also do a fair bit of real estate. My practice also involves some amount of real estate, title diligence, and transactional support. But primarily, a big chunk of my practice is devoted to litigation and arbitration. Having said that, I think arbitration as a topic itself doesn't need any introduction. I'm sure all of you are aware as to what arbitration is and how it transpires. Uh, Arbitration is one of the forms of alternative dispute resolution, along with mediation, conciliation, and others. It is supposedly a cost-effective and time-bound remedy as opposed to traditional litigation. But sadly and very unfortunately, arbitration remains luxury litigation, and it remains exclusive to certain members of society who can only afford it, and it isn't as inexpensive as it is made out to be. I'll maybe talk a little bit more about that. Arbitration in India is governed by the Arbitration and Conciliation Act of 1996, which again was modeled around the UNCITRAL model law, which most countries around the time have adopted for arbitration. There have been a few proposed amendments to the Arbitration Act, some amendments incorporated as well, and some which are awaited, especially those which streamline institutional arbitration and bring about more change in that sense. I will dive more into what is institutional arbitration very shortly. Coming back to an introduction of arbitration, like I said, arbitration is governed by the Arbitration and Conciliation Act of 1996. Arbitration primarily is an alternative to court litigation, which, as all of us know, can go on for a long time. Arbitration is designed to be time bound. As of the current stipulations in the Act, an arbitration proceeding has to be completed within 18 months of its institution. And arbitrators are very strict in terms of enforcing these timelines. Having said that, arbitration is also supposed to be cost effective while considering the court fee and other expenses that would transpire in case of a normal court proceedings. Arbitration only involves the cost of the arbitrator, which is again given in the Schedule 4 of the Arbitration Conciliation Act, which would be the schedule for calculating the fee of the arbitrator, depending on the claim amount therein, or depending on the number of arbitrators that are to be appointed in that particular matter. Having said that, arbitration in India, while it was intended to be a widespread tool that would effectively clear the pendency in the current litigation system and the current court system, unfortunately, it hasn't been able to make that penetration into the judicial services in terms of being an effective ADR mechanism. While along with mediation, it has been an effective tool for commercial matters and for high stake disputes. And unfortunately, it has been restricted to such high stake disputes. It has been restricted to 5-star or luxury litigation category. The reason I say that is because the moment I say arbitration, anybody in the profession would only be able to think of an arbitration proceeding being conducted in a 5-star hotel where retired judges would come and sit there and have the entire day in the hotel in one of the conference rooms in these hotels. And generally, these expenses of every arbitration proceeding are also borne by the parties. So it significantly adds to the expense, and sometimes it makes it much more expensive than regular litigation itself. Having said that, the intent of arbitration or the intent of the Arbitration Act itself was not to make arbitration so exclusive or so expensive or to have it on an ad hoc basis. Of course, ad hoc arbitration does exist. With that, I come to the two types of arbitration that are existing or that are predominant in India, which is ad hoc arbitration and there's institutional arbitration. So ad hoc arbitration is your arbitration that would take place at, say, at any unspecified location. It could happen at the arbitrator's residence, or it could happen at a particular hotel, or it could happen at an office or a temporary setup, which is of the arbitrator's choosing and agreed by both the parties. And an institutional arbitration, on the other hand, is a much more formalized setting where an institution, so all of you would have heard of institutions like the MCIA, which is the Mumbai Commercial International Arbitration Center, or sorry, Mumbai Center for International Arbitration, or even the IAMC, which is the International Arbitration Mediation Center, Hyderabad, or even of international institutions like the IFC, SIAC, or even LCIA, which doesn't exist anymore. But I'm sure you would have heard of such institutions when it comes to both domestic and international commercial arbitration. I'll come to why institutional arbitration is important for international commercial arbitration, and why, if we are serious about making India a hub for international commercial arbitration, we need to look at taking institutional arbitration much more seriously. But before I delve into that and into institutional arbitration itself, I'd like to just say a few more things about ad hoc arbitration and arbitration as it currently is, and the downsides of that. Now, arbitration in its current form, as I said, remains a luxury litigation, remains a five-star litigation, because the reason being most of the proceedings are ad hoc and are conducted at locations which are generally very expensive and inaccessible to the general public. And the penetration of arbitration at the moment remains only as far as commercial disputes. I feel the application of arbitration could be limitless if applied to other forms of disputes, maybe domestic disputes, family disputes, or even other things where mediation and arbitration could be very effectively used. And even I think other family disputes other than matrimonial matters, where there are property suits or other disputes which are long pending, other civil suits which are long pending in a regular court, could, I think, easily be referred to arbitration, and could be effectively resolved there. Another, I think, systematic block to arbitration in India is the dependency on the traditional judges. What I mean when I say that is, generally, whenever you see an arbitration matter, you would have a judge who is a retired High Court judge, a retired Supreme Court judge, or a retired District Court judge. Now, while having judges of this nature is definitely a good thing, and would add, most likely very well to the proceedings itself. Sometimes what ends up happening is these judges, given their background as training, given their background and training as judges in one of the higher courts in the country, they would generally be very insistent in procedure. And when it comes to the Arbitration Act itself, the only procedure that matters is the procedure laid down by the arbitrators and by the rules of the institution, if at all it is institutional arbitration. And more often than not, a lot of judges and parties get hung up in technicalities of CPC, such as evidences, chief affidavits, and other things. Whereas arbitration is generally much more lenient towards these requirements. I've seen in my personal experience a lot of arbitrators insist on referring to them as your lordship in an arbitration, whereas in an arbitration you can simply refer to the arbitrator as sir, even if the arbitrator happens to be a retired judge. However, it is generally out of respect that we continue using the terms that we use for them. Having said that, I think India as a country would really benefit from having arbitration being more widespread if it were decentralized in terms of the arbitrators. What I mean when I say that is that it's not necessary that an arbitrator has to be a retired judge or has to be of a certain experience. If you look at foreign countries, you have people specializing in a particular field, even lawyers who are maybe not judges, also being appointed as arbitrators for certain specialized disputes. You have specialized arbitrators being trained as arbitrators right from a very young age. This could be for construction arbitration, this could be for arbitration in other matters. Sometimes you also see in other countries where some people are not even trained lawyers, but they are arbitrators in certain types of disputes. And I think that distinction is really important to have in India, because in India we have a very close-minded view to arbitration in terms of having only litigating lawyers argue arbitration matters and having only retired judges generally appear as arbitrators. Whereas I think the entire system would really benefit from having specialized arbitrators, irrespective of their background, irrespective of them being judges or not, specialized arbitrators depending on the nature of the dispute or the nature of the arbitration itself. I think that is something which will really change the system. So just to recap what I've said so far, currently the lacunae in the Indian arbitration system are that it's very expensive. It is primarily ad hoc, and there is preference of judges, especially in the traditional judiciary, which is impacting, I think, the penetrability itself of arbitration, if I may use that word. And it's also affecting how widespread arbitration can really be and how effective it can really be as a tool. Combined with all of this, the fact that arbitration itself is becoming expensive because of all of these factors. Now, coming to institutional arbitration and what that really means is, of course, I talked about ad hoc arbitration, which is currently very widespread. Institutional arbitration, what it simply means is arbitration that is conducted and that is overseen by an institution. So as I said, I named a few like the SIACA, the MCIA, or even the IAMC, which we have in Hyderabad. We also have the Delhi International Arbitration Center. We have court annexed arbitration centers as well, which I will come to in just a bit. Now, primarily an arbitration institution would be, or an arbitration center as they're called, would be typically a center that is having arbitration and mediation capabilities, and it would have a panel of arbitrators. And it would have, each arbitration center would have its own rules, which are updated from time to time. And these rules will determine what type of matters those institutions will take, what type of arbitrators are empaneled with them, what would be the procedure for appearing, what would be the procedure for filing the claim statement, for filing the statement of defense, the timelines, the mode of the arbitration, and other things. Now, the advantage with having institutions, I've also seen a few ad hoc arbitrators adopt the mechanism of conducting arbitration proceedings online, which I think makes it very convenient for the parties and very convenient for the counsels appearing as well. But having said that, institutions in general practice, especially given the advancement of technology nowadays, institutions that oversee arbitration matters, that conduct arbitration matters, generally practice having matters conducted through VC, which makes the entire process much more cost effective, as opposed to having a physical hearing in in a hotel premises or in any other rented accommodation on a weekly basis. Having said that, institutional arbitration also has the advantage of having a panel of arbitrators, and these panels of arbitrators are not necessarily just retired judges. They have panel of specialized arbitrators, sometimes even members of the international bar and members of the international community as well, depending on the nature of the arbitration, could be on the panel and could be used for these proceedings. Coming to the different types of institutions, of course, we have private institutions, and you have also court annexed institutions or institutions run by the government. For example, in Karnataka, they have something called the Karnataka Arbitration Center, which is the High Court of Karnataka's own arbitration center. And whenever an application for appointment of arbitrator is filed in the Karnataka High Court, generally these matters are referred to the Karnataka Arbitration Center. And one of the arbitrators on the panel of the Karnataka Arbitration Center is appointed to adjudicate these disputes. We have court annexed arbitration centers in most states. and I think these centers are doing fairly well. And I think the push going forward should be towards institutional arbitration. I'll also come to why the push going forward should be towards institutional arbitration, especially for commercial arbitration and more specifically for international commercial arbitration. But speaking a little bit more about court annexed arbitration centers, I think the advantage with having an arbitration center next to the court is that there is a lot of time saving in terms of the appointment of the arbitrator. I'm sure most of you must be aware that under Section 11 of the Arbitration Act, there is a mechanism for approaching the High Court of a particular state for appointing the arbitrator. This is in case that you are initiating arbitration against a particular party and they're not responding to your choice of arbitrator or not responding to the appointment of arbitrator. You have, as a party, every right to approach the High Court to appoint an arbitrator. and the High Court in turn appoints an arbitrator or an institution. And in these cases nowadays, wherever there is a court annexed institution, the courts are appointing the court annexed arbitration center. And thereafter, these arbitration centers are taking forward the arbitration proceedings. I think institutional arbitration, whether it is private institutions or whether it is court annexed institutions or government institutions, I think institutional arbitration is the way forward, especially if India is looking as a country looking for widespread arbitration matters, or looking at increasing the number of arbitration matters and looking at decreasing the number of matters that are pending before the traditional judiciary. It is really important to have arbitration centers, both private as well as court annexed, in order to facilitate and have more and more arbitration matters. So coming to why institutional arbitration is key for international commercial arbitration. Historically, if you look at commercial arbitration and the kind of nature of the parties that are involved in commercial arbitration, you would see that these are traditionally companies, and these are for cross-border deals and million-dollar deals that or even billion-dollar deals that end up going into arbitration. Traditionally, there have been institutions that handle these kind of disputes. For example, look at the SIAC, or even the Hong Kong Arbitration Center, or the former LCIA, the courts and even the arbitration centers in Dubai, for that matter. Traditionally, sorry, is somebody trying to say something?
No, sir, please continue.
Yeah, sorry. So if you look at these matters, traditionally India has never been really a choice or a contender among these locations, amongst Hong Kong, amongst Singapore or Dubai, as a hub for arbitration. Currently, most international disputes are adjudicated by the centers located in these cities, and for most commercial transactions, these are the preferred hubs of arbitration. However, if we want to change this in the future, the reason why these locations have been successful is because the push that institutions have received there, and is because the institutions in these locations are driving. And when I say institutions, I mean the arbitration institutions. They are the ones who are driving, and they are the ones who are handling the high stake arbitration matters in these cities, be it in Dubai, be it in Hong Kong, be it in Singapore, or even formally in London, or even New York and other places in Europe, for that matter. You see, there is a reason why you have arbitration weeks, or such conferences happening in these places, be it the Paris Arbitration Week or the London Arbitration Week, or even the Riyadh Arbitration Week, or the Dubai Arbitration Week. The reason why these events happen there is because the strength of the institutions and the sheer value and number of matters that are being adjudicated by these institutions. So if India really wants to make a mark in the commercial arbitration space, I think we have to focus on improving our institutional arbitration centers, be it our private arbitration centers such as your IIMCs and MCIAs, or be it the court annexed centers such as your Karnataka arbitration centers and your Delhi International Arbitration Center and others. I think it is really important, and there are a lot of Supreme Court judges also who have in the recent past opined on similar lines, where they said that if India seriously wants to be a hub for international commercial arbitration, then institutional arbitration is the way forward, because traditionally businesses and commercial transactions, or the stakeholders in commercial transactions, have always preferred institutions in the other cities that I've named, and I think that would be the way forward for arbitration really in India. And one of the other benefits of having institutional arbitration is that there is a certain accountability, and there is a certain process that is followed by these institutions, which sometimes might be missing in an ad hoc arbitration, or while having arbitrators appear independently. There might not be a certain organizational structure to the flow of the arbitration proceedings. But whereas in the case of an institution, that would definitely be followed, and will also ensure that there would be no delay in the arbitration proceedings itself. For example, in an ad hoc proceeding, if the arbitrator, the sole arbitrator, or if the arbitrators are not available for some reason or are unwell, the arbitration would most likely be would suffer or would be delayed. Whereas in an institutional arbitration, if at all an arbitrator is indisposed for that particular hearing, the institution will be able to substitute him with or her with another arbitrator who will be able to take up the proceedings for that particular day. So I think it ensures a continuity of proceedings. It ensures a certain level of professionalism in how the arbitration proceedings are conducted. So I think from that perspective, institutional arbitration becomes very important, and it should be the focus of parties as well as us as practitioners going forward. Um, uh, I think just summing up everything I've said, I would, in conclusion, like to just add that as a country, we are making the right move towards, or the right moves, I would say, towards making India a center for arbitration. The reason, or rather, an international hub for arbitration. The reason I say this is because of one of the welcome moves we've seen recently with the introduction of the arbitration bar of India, where a separate a professional bar for arbitration has been set up as opposed to the traditional bar that we have for litigation. It is important to have not just an arbitration bar of India, but also to have a separate arbitration bench or a panel of arbitrators, specialized arbitrators across the country, which would not include only retired judges, but would also include specialized arbitrators from all fields and all walks of life. And hopefully this would lead to increasing the number of arbitration matters and just the nature of arbitrations that are dealt with. As I said, arbitration doesn't have to be restricted to commercial matters alone. It would be great to see arbitration penetrating into other types of matters and have other civil suits and other matters, being adjudicated in arbitration. I think this would really help the pendency, and this would really help the overall state of the judiciary in India right now. And I think this would be, the way forward. With that, I think I would like to conclude. But if there are any questions, I would be more than happy to answer the same.
Okay. We'd like to open the floor for questions. Anyone who has a question can please.
Hello, sir. Am I audible?
Yes, please.
Hello, sir. It's great to see you post that virtual interview we had with you recently.
Yes,
I
thank
just
you.
have one question. How would you recommend young lawyers to develop expertise in this particular sector since it's up and coming and evolving?
Sure, that's a great question, and I think my answer to that is very simple. It like any other sector or any other field of law, it just requires you to put efforts in that direction. Maybe start reading articles put out by people who are experts in arbitration, and also pursue internships or work with people who are practicing in that field, people who are handling arbitration matters, officers that are handling arbitration matters, and maybe even look at reading scholarly articles or other things which have been put out, and also just generally use the online resources and read. Of course, arbitration proceedings themselves are private, but read about matters that have gone to arbitration, or even explore reading judgments about appointment of arbitrators. I think this would really help young students move in the right direction and at least understand how the procedure around arbitration takes place. While you might not be able to read the entire arbitration proceeding itself online, you can read everything else around it, which is pretty much public information. And if you're working with or interning with an office which handles arbitration matters, then I'm sure they will let you read some of their arbitration files as well. So I think ultimately, there is no substitute to hard work if you're able to work with people who are working in this field, and if you're able to read more and more, I think you should be able to make it, big in arbitration.
Absolutely, sir. We have so many moods and research papers ongoing by our students, which is why I think it's a very evolving field to take an interest in. I would like to call back.
Good afternoon, sir. I hope I'm audible.
Yes, please.
Yes. I had a question as to whether you think institutional arbitrations are a market in the conventional sense, because one of the reasons why Indian institutional arbitrations, like arbitration centers, Indian arbitral institutions in general, don't get a lot of concentration of population is because even if there are two Indian parties, they would rather go to SIAC They would rather go to London, etc., for solving arbitration disputes, right? So do you think the fact that there's high quality control on those arbitration centers that are international nature is actually what's leading to Indian institutional arbitration at least not being as popular as it should be rather? Or do you think it's not a zero-sum game at all and like it's purely a quality metric where there's enough demand in the market where you could have dispersion across all international arbitration institutions as such?
Sure. Thanks. Thank you so much for that question. That's a good question. So to answer that, I would say it's not just a quality metric. I think it's not all about quality because I have appeared in some of the international arbitration centers you mentioned, be it SIC or even DIFC for that matter. And what I've noticed is, while of course the quality is definitely there, the quality is not lacking. Just a second. Yeah, so it's not that there is quality lacking in Indian arbitration centers or in Indian institution centers. I would say, or I would dare I say that the same level of quality exists. Of course, one of the factors is that the number of instances or the number of matters that go to arbitration, especially commercial arbitration, to the centers in those countries is higher. So of course, it's a question of more demand that is there, as you rightly pointed out. But it's also to do with the awareness or with the likeliness or the likelihood of going to arbitration, which happens a lot more in commercial transactions in those countries. Whereas in India, a lot of times people would prefer exploring other options, either a litigation or in terms of some sort of form of a negotiation or settlement, as opposed to going to an institutional arbitration. In fact, I've also seen a lot of Indian parties prefer ad hoc arbitration, even given the downsides, as opposed to institutional arbitration. And uh, it's also, I think, a resultant of the fact that the number of institutional arbitration centers in India is far lesser as compared to these countries. So I think if we focus on, while the quality is there, I think if we focus on increasing the quantity of these arbitration centers and the awareness towards arbitration, and in general incentivize parties to go for arbitration as opposed to other forms of litigation or ADR, I think that would really help us going a long way in terms of making India a hub for international commercial arbitration.
Thank you so much, sir. On behalf of Rajiv Gandhi National University of Law, we extend our heartfelt thanks to you for gracing us with your presence today.
Your thoughts on rise of institutional arbitration and how we need better implementation are truly given us a fresh perspective. We thank you for joining us today, and we hope we have the opportunity to host you again in the future. Until then, we wish you best of luck in your endeavors. Thank you so much, and we hope you have a wonderful day ahead.
Thank you so much. It was a pleasure to be here, and thank you so much for having me. And once again, my apologies for not being there in person. I look forward to visiting your campus sometime soon and meeting all of you in person. Thank you so much.
Definitely, sir. We look forward to hosting you. Thank you so much.
Thanks a lot.
Moving further, when it comes to mergers and acquisitions, every deal tells a story. And our next speaker has been the master narrator of many. With nearly 17 years of experience across the M&A landscape, he doesn't just close deals, he architects them from the ground up.
It is our absolute honor to welcome Mr. Karthik Jain, partner at JSA, whose vast experience spans mergers and acquisitions, joint ventures, private equity, venture capital, and much more. Whether it's structuring a high-stakes cross-border transaction, advising Fortune 500 companies, or steering complex corporate disputes, he has done it all with insight, precision, and strategy.
From PepsiCo's strategic exit to Toshiba's joint venture to APG's billion rupee real estate investment and Boeing's defense restructuring, he has been the trusted legal architect behind the deals that have shaped industries. His clients span continents and sectors, yet he brings to each transaction a rare ability to distill clarity from complexity. His expertise extends beyond M&A into corporate governance, employment law, white-collar crimes, and cross-border commercial disputes, making him not just a lawyer, but a counselor to capital and commerce.
A prolific speaker and a regular contributor to the legal thought leadership, a professional who embodies both intellectual depth and business instinct. He joins us today to illuminate us on one of the most dynamic spaces on Indian business. We are thrilled to invite him to speak on the topic, the evolving M&E in India, opportunities, challenges, and legal insights. So the floor is all yours.
Thank you. Am I audible? Okay. So the topic that was given to me was evolving M&A and the opportunities and challenges that it throws up. So I prepared a quick PPT. Of course, that's just a reference point. So in case you have any questions, please feel free to ask, okay, on a real-time basis. Can you just project if you can just put it, okay. Okay, perfect. So let me just tell you that how the M&A evolved in last couple of years. And the time frame that I've picked for this discussion is post the COVID time. So in 2020, when the COVID started, I was working on at least 5 to 6 live transactions. Okay, and I just realized that out of those 6 transactions, 4 transactions automatically and immediately fell that time. And I was thinking that, it's a doom day and a lot of these matters are going to go. But, it gives me a different perspective, because even though those 4 transactions that time fell through, there was a different stream of work that came into the firm. For example, a lot of lease deeds were getting terminated. Okay, a lot of companies were firing people. Lot of contracts needs to be relooked. Okay, which gives me a perspective that even though it is a challenging time, but as far as lawyers are concerned, the hard reality is that we can find opportunities in that kind of a troubling time as well. It is a simple saying that whether the stock market goes up or goes down, you still need a stockbroker, okay? Either to sell or to buy. So even though the private equity deals or a venture capital deals went down, but stress sale was still happening that time. So mergers and acquisitions were still happening, okay? And it gives you a perspective that in early 2020, there was a dip in the corporate M&A field, but after a period of 9 months, okay, it again picked up. And because a lot of private equity players and venture capital players were sitting with a dry powder of lot of amount of money that they raised from their LPs and GPs, they were sitting with a lot of cash in their bank account. Okay. So immediately in 2021 and 2022, there was a huge spike in the M&A transactions. Okay. In fact, we as a firm, we had the most profitable year as far as 21 and 22 were concerned. Again, after 2022, because of multiple challenges at the global level, there was a dip in the private equity and venture capital deals, but still the strategic M&A was still happening. So what were some of the reasons, okay, of the challenges? So this slide, you will see that in last couple of years, there have been a sense of uncertainty in the market because of several reasons. It could be the relations between US and China. It could be the elections, which was scheduled in US, and of course, Trump won the battle. But still, the world is going through an uncertain time where you may see that every now and then Trump talks about revising the tariffs. Okay, there is a war going on between Russia or Ukraine. What happened with Israel and Palestine. So even though it is an uncertain world, the M&A transactions are still happening at a huge pace. Okay. So we as a corporate lawyer, we have to find the opportunities even though in these challenging and troubling times. Okay. Now let's discuss from our perspective what are some of the key growth areas that we as a firm at least see where a lot of M&A transactions are going to happen in the near future. First and foremost is the insurance sector. Okay, this is one sector which, as far as we believe, is one sector which is really untapped. particularly a lot of M&A transactions happen cross-border, okay, wherein some foreign players are coming into India, and insurance is one sector which earlier was not open for 100% FDI, okay. So that is one sector that we feel has a potential for growth. You have the entire medical space, okay. It can be hospitals, it can be, any kind of drugs, pharmaceuticals. The entire space has a lot of potential. Then you have financial services, all the cryptocurrency, data mining, these NBFCs, fintech companies, okay, a lot of M&A is happening in that sector. Technology, media, energy, all these sectors have a lot of potential, and we feel and believe in next 10 years, India is going to see a lot of overseas cross-border M&A transaction, whereas overseas companies are going to come into India, and for certain mining and resource sectors, the Indian companies are going to go for outbound transactions also, particularly in countries like Australia, Saudi, where there is a lot of natural resource available in those countries. Okay. Now, let us see some of the other challenges that might be there. Now, you can look at it as a glass which is half full or half empty. From our perspective, we look at it as an opportunity. From certain sectors, it may look like it's some challenges. So if you will see in last one decade, and I'm not going too far back in time, I'm just focusing on last 10 years. The law has completely changed, particularly from the corporate practice area. The law has completely changed. If you will see, the entire Companies Act has changed. The entire insolvency regulations are totally new. Okay. You will see the entire competition practice have been set in last 10-15 years. If you will see, the entire Foreign Exchange Management Control Act has completely been revamped. Okay. There are structures which never existed. So when I started my practice in 2007 and 8, we didn't even know that there can be an earn-out structure that we can incorporate in a corporate M&A transaction. I didn't know that I can actually incorporate a share swap structure. Okay. The entire business transfer agreements, okay, nobody knew how the licenses are going to get transferred. If you will ask me, in certain states today also, there is no clarity on how the stamp duty laws are going to work. Okay, they are pain when you start, dealing with them. But you will see that nobody used to talk about ESG laws. Okay, when I started, nobody talked about, what is the social responsibility, what is the governance. Nobody used to talk about environment that time. But today you will see there are a lot of funds where they have a legal mandatory requirement to comply with ESG laws. Okay, they have to do a reporting, they have to give a certificate. So this entire practice area is too new. Okay, for anybody to tap in. The anti-corruption, anti-bribery, nobody used to talk about it in India 15 years back. Okay, lot of Indian companies used to do certain activities which went unnoticed that time. Today, if a venture capital or a private equity fund is investing into a Indian company, they mandatorily required, okay, to run these kind of anti-bribery and anti-corruption check. There is when we used to do due diligence, okay, back in time in say 2008, I never did a due diligence on an anti-bribery, anti-corruption, section or a practice area. But today, in last 4 years, I have done almost 15 due diligences, which are only focusing on anti-bribery and anti-corruption section. Okay, so FEMA, press note 3. Nobody imagined that India can take a stand against the land border neighboring countries and stop the investment from there. Okay. If, for example, 10-15 years back, anybody used to talk that, okay, fine, we are going to say no to a foreign investment, nobody imagined that to happen. But the government took that stand, and press note 3 was a reality so as to ensure that the opportunistic takeovers are reduced. Okay. Competition law. Nobody thought that deal value transactions can also be tapped in by the CCI Commission, and which requires approval in India, even though the transaction is happening at a global level. Okay. Companies Act, I told you, the entire Companies Act got revamped. Nobody thought that so many sections, first of all, nobody thought that first so many sections will come up with such kind of a severe penalties when they were incorporated in 2013, and then later on they also got decriminalized. Okay. For the private companies, for the public unlisted companies, nobody thought that the government is going to come up with a dematerialization of shares. But today, if you will see, one of the most difficult part is to ensure that the transaction gets closed on a particular date, ensuring the shares are also dematerialized and the closing happens in a demat share format. So I'm saying the law is changing, it's evolving. Now you can look at it as an opportunity, or you can look at it as a restriction. Okay. Startup world. Okay. Again, when I started my practice, we always used to focus only on big strategic players. Okay, say who have plant and machinery, who have big factories, who have good infrastructure. But then round about 2012, in fact, that was a time when I first met a startup founder, and he told me, Karthik, can you do a fundraise for me? And I was surprised to see, the kind of ask that came in the transaction documents, the kind of commercials they had for the fundraising. It was a complete new practice area. So what I'm trying to tell you is that in last 5-10 years, the entire landscape has changed, and it's going to go on. Say, for example, I can't even imagine how the legal practice is going to look like 10 years now down the line, okay, or 10 years in the future. So things are going to change. So is the documentation. So is the legal set skills, that you should have. The startup, when they came, nobody thought that they can be such a boost for a private equity or a venture capital deals. Now you will see there are multiple series of rounds that happens in a startup, be it be a seed round, raising the funds from friends, relatives, a lot of these new boutique law firms, okay, they specialize in raising the funds for seed round, series A round, series B round, okay. Nobody thought that a person can set up their own boutique law firm and then also can set up such kind of a flourishing practice out of this practice area, okay. Then you have promoters equity, you have a bridge round, you have the venture capital debt rounds, okay. You have multiple series. Now today, for example, in last couple of years, starting from Zomato, you will see that they are also going for IPO. Means last 2 years, the best practice area for our firm also has been the capital market IPO practice area, because there are almost 25 to 30 IPOs that each team is doing from the capital market side. So, for example, if somebody asks me today, okay, Karthik, whether I should go for litigation, I should go for, corporate M&A. Corporate M&A in itself is such a vast field, okay, and you have so many multiple different practice areas within the corporate practice area only. And we divide it in service lines. Okay, so you can have a specialization, say, in only in competition laws. You can have specialization in aviation laws. You can have specialization in infrastructure, electricity, mining. Means the world is endless. Okay, and I haven't even touched upon the new upcoming sectors like AI, data privacy. Those are much niche practice areas. For example, even the fintech laws are quite new. If you will go and start reading, searching on RBI's notification and circulars, you'll be surprised at how the payments are going to go through, okay? And lawyers are needed for each and everything. So, this restricted and release shares, I still remember when this concept came on my desk way back, and I'm talking about 2013 or 14. I was surprised to know that how can somebody build a concept where you have shares, but you are not entitled to them? This concept, if you will start reading, and this is a concept you will only find in startup deals, wherein you have a bunch of youngsters who have not proved themselves till now, but still they are raising, say, 300 crore, 400 crore. So venture capital wanted, venture capital funds, they wanted to have some kind of a control on the founders. This clause you will never find in a strategic M&A. And when this clause came, and I was reviewing it from the legal standpoint, I was wondering that how it can happen that the founders have the ownership of the shares in their hand, but still if they tomorrow want to sell it, they can't sell it because those shares have not been vested, in them. And they have to spend at least 4 or 5 years to get those shares, which are actually allotted to them on day one, but they still can't do anything about it. So this is a very interesting topic. And I'm saying, when you will start reading all these transaction documents, you will see there are so many interesting clauses, and there is a reason for everything. So for example, if you will see a startup transaction document, you will realize that instead of equity shares, the venture capital and or a private equity player always takes either a CCPS or a CCD. Now there is a reason attached to it. Okay, when sometimes people come and say, I want to be a M&A lawyer, and I ask them, do you know the reason why, the venture capital people, they only take CCPS? There is a reason to that. It can't be that everybody is chasing the same instrument and there is no reason why. Okay, so we have to be very clear. If we want to go into a particular field, we have to do the research first so that you can convince the other person that yes, this is the practice area I want to focus on. Okay, I'm very conscious of the time allotted to me. So I'm trying to wrap it up also slightly quicker, but I'll be more than happy to answer any questions that you may have, be it relating to this topic or any other as well. But because I was coming to a law university, I also thought through it that what is something that you might be more interested about. So let's discuss about role of a M&A lawyer, and I'm just focusing on pure play of transactional lawyer. So I'm not getting into a specific service line. So I am not going to discuss, say, mining or technology or anything. Pure play M&A, how and what is expected out of a lawyer. Okay, so if you will see the entire life cycle of any M&A, there are so many things that a lawyer is supposed to do, starting from when you receive an initial term sheet, okay, for any transaction. You are supposed to know about that industry. Okay, you can't that time tell to the client that, you know what, I don't know how the manufacturing happens. I don't know how, so for example, I was doing a deal. By that time, I never worked on entertainment or cinema laws. Okay, and that client was from, he was running a multiplex. I'm talking about like 2009. I spent one day, only one day, in understanding all the intricacies that can be there in the cinema business. Okay, how the cinema business is done, operated, starting from the distributor to how the cinema chain is run, why single plex is getting converted into multiplex, what is the money that a distributor makes, how the film gets distributed in multiple states. And I'm saying, when you do that, you will understand what is the challenge that the client is facing. What is the challenge that your client as an investor should be aware of? What kind of a risk we should cover? What are the licenses that get triggered in that particular industry? So I'm saying it starts from the due diligence. You can't run a due diligence on a particular target unless you understand their business. Okay. So it starts with the due diligence, then you understand what are the regulatory challenges, what is the research that goes into any M&A. If any M&A lawyer thinks that I can be a successful M&A lawyer only by knowing how to draft the transaction documents, it's impossible for him to be a good lawyer. I'm telling you, because M&A is one field which is not restricted to a particular sector. You need to know a little bit of competition law also. Until unless you know a little bit of taxation, you can't structure a good deal for your client. Until unless you know a little bit of employment law, you can't structure their ESOP entitlements. Okay, you can't ensure that the main CEO or the management team is sticking around the company post the acquisition. Until unless you know a real estate laws, you cannot do a due diligence on their factory, on the land titles. You can't do a due diligence on the long-term leases. Okay, all of this forms part of the M&A practice area itself. So you can't tomorrow say, I don't know about this particular area of law, but still I want to be an M&A lawyer. So that research needs to go in. So you have to be a good researcher, okay, to be a good M&A lawyer. But at the same time, you have to be a good draftsman as well, because drafting a transaction document is not as simple as drafting a English email to the client, okay, because the way the agreements are drafted, okay, their entire flow is totally different. So of course you have to draft as well. Now, in again, not taking away the credit, but say in litigation, even though you draft a petition, you still may end up getting a senior counsel to argue your case before the bench. But in M&A, a lawyer, as an M&A lawyer or a corporate practice lawyer, it can't be that somebody else is researching, somebody else is drafting, and somebody else is negotiating. You have to be a good negotiator as well. Now, the challenge with that is, in a room full of 20 senior management client representatives, you will just be awarded hardly 30 seconds to articulate your point in a manner that the other side also understands and they appreciate the challenge that you're facing and you're able to win that point. So being a negotiator is technically, so to speak, is the most difficult part of the entire journey. And then, of course, there are assisting with the closing actions, and there are multiple things that needs to be done. But I'm just telling you, it's the ice tip of what exactly is being expected out of a good M&A lawyer. Okay, and I'm not right now touching upon the other aspects of this legal practice area, because client relationship management, handling their expectations, timely delivery, all these comes as a part and parcel of what is expected out of the corporate M&A lawyers. Okay. Let me. Is it not working? Yeah. Sorry. Can you just move to the next slide? Okay. Skill sets of a M&A lawyer. The first day when I joined, okay, my law firm, hey, I'm just trying to share a practical, or a real incidents that happened. That particular day, there was a meeting that was scheduled by my partner of that time with a Japanese client, okay? And, I was going through the file and everything. In the meeting, I went into the meeting carrying 2 or 3 box files, okay, with me. And my partner was surprised. And I was surprised because by the end of the meeting, nobody discussed anything relating to law. Okay. What was being discussed was at a very high level, 35,000 feet kind of a picture. But at the same time, I realized the client was very happy. So what is very crucial is to take care of the client's expectation. Of course, I'm saying knowing the law, giving a good advice, it is a part and parcel and very important, but I'm saying it is not the only necessary thing. Okay. So what do you need? You have to be very good with negotiation. You need to have an eye for detail. When I joined the law firm, no, I was very surprised. One email I was writing for 3 times. I used to write it. I used to take it to my partner who was senior. He used to revise it, and that revision was not related to law. It was only related to the language, the way it is drafted. Okay. And I used to feel that why my partner is focusing so much on commas, full stop, how to write, whether it's an active voice, passive voice. But later on, after say 3, 4 years, I realized that is very important. It's not what exactly you're saying. It is also very important how you're saying what you're saying. So therefore, you have to have an eye for detail, wherein when you are dealing with foreign law firms, they actually, value and see each and every word of yours.
And if you're using the, say for example, let me give you an example. And in case you get the opportunity of meeting Jyoti Sagar ever, he focuses so much on drafting. So if you have written in the event, he used to cut it. He used to say, why can't you just write if? Why are you using 3 words? Because we are living in a world where nobody has the time. Okay. So if you are going to write the same thing using 2 pages, which you can convey in half a pager, still maintaining the complete essence of that topic or that paragraph, it is always better to write it in half a paragraph, okay, rather than using 2 pages. So that eye for detail is very important. Financial acumen, okay. A lot of times I meet lawyers who say, why do I need to understand about the balance sheet, how it's read? If you are a M&A lawyer and you say that I do not know what is the net worth, whatever, or I do not know what is the concept of free reserves, I do not know what is the concept of, say, share capital or different capitals, okay, I'm saying you will find it very difficult to structure a proper corporate M&A transaction. Okay, so financial understanding is also very important when you do that. As far as industry insider is concerned, as I said, M&A deals happen in all the industries. So it can't be that you say that, I don't understand this industry at all, or I don't know how the Drugs and Cosmetic Act is going to work for a FMCG client. I don't know how the FSSAI is going to work, Legal Metrology Act. I'm saying you are supposed to know all these acts. Means, you can't say that I am only going to practice in Companies Act. That's it. It can't happen. Time management master. Okay, most of the time, and I'm just speaking out of my experience, particularly for tier 1 law firms, the size and scale of M&A transaction is huge. Now they run into, say, 500 crore, 300 crore, 200 crore. We as lawyers cannot dictate the timelines for that kind of a deal. We cannot say that, the investor is ready to pump in 800 crore, but we as lawyers, because we are not able to draft the agreement, let's delay it by a week. Okay. So most of the time, the M&A transactions, they come with a very, very stringent timelines. Both the sides want to close the transaction on a urgent ASAP basis. So time management becomes very, very crucial. Okay. Risk radar, okay, which basically means that as a corporate commercial lawyer, you are supposed to know what are the risks and challenges that may come. And we have to think in the future. So for example, these agreements, okay, they have to withstand the time clock also. So there might be some agreement which, say, Mr. Jyoti Sagar might have drafted in 2005, but that agreement is still holding good because those joint ventures are still running. It cannot be that he drafted it in 2005 thinking, okay, fine, this is the law and this is the only risk I will foresee. We have to also think through a lot of contingent events which may occur in the future. So yeah, that is also one of the important things we should focus on. Okay, now this is why you should choose M&A law. Of course, I leave that to you. I'm just skipping this slide, but I'll be more than happy to discuss it later on also. Some of the challenges that are being faced by the M&A lawyer. So I've just told you the rosy side of this entire discussion. Let's now face it, what it means to be a M&A lawyer. So some of the challenges are linked to the economy. Some of the challenges are linked to the legal system or the sector that we are going through. For example, when I started my journey back in 2007, there were not a lot of law firms that time. Okay, it was a challenge also, and it was an opportunity also. So, for example, if we wanted to switch over from one firm to another, the options are very limited. But at the same time, the opportunity was because there were very few lawyers in this practice area. We got a very good exposure. We also got very good mandates that time, but today the market is getting cluttered. And when I say cluttered, it basically means that you have now a lot of law schools, you have a lot of people or students getting into the legal field. You have a lot of law firms, not only big law firms, small law firms, and I'm actually telling you, some of the boutique law firms are also pretty good. Okay, you'll be surprised. Some of the senior partners from big law firms, they have shifted and they have started their own, and they are doing very good job. Of course, now increased regulatory oversight. Now, government is also getting very serious about certain things. Okay, they are penalizing also a lot of companies on non-compliances on regulatory front if they are not following the legal provisions. Okay, correctly. There is definitely the oversight has increased. A lot of investigations are happening. You may have seen a lot of raids, EDs. Penalties are getting attached to people in the personal capacity as well. So one has to be really certain of what exactly they are doing, and if they are not compliant from the legal standpoint is concerned, of course they can face the music. Okay, in future. Handling cultural integration issues. This is very interesting. We are going global to a very large extent. Okay, people might be from a particular state studying in some other state, joining in some other state. It could be in India, it could be overseas also. So handling these cultural fits and integrations can sometimes be challenging. This is from the legal sector perspective, from where we are. But I'm saying, if you are a M&A lawyer, post the M&A transaction closure, okay, if one company is merging into another or one company is acquiring the other company, it is also seen a lot of time that the company that got acquired, they may have a cultural fit issues. Okay, so it works both ways. Okay, networking and relationship management. Now, because of this globalization, okay, networking and relationship management became very important. So when we started our journey in 2007-8, we never thought that we will be supposed to take care of, say, relationship with the company, okay, or the client, or foreign law firms. Now you have this social media, you have, LinkedIn, it's open to all. So managing and networking the relationship is a very important challenge that you need to handle. Of course, AI, everybody knows. Nobody, everybody knows the concept, but nobody knows that how it's going to impact. I personally feel that AI is something which is unavoidable. Okay, a lot of law firms are going to adopt and adapt the AI tools. Again, the usage and integration would depend on several factors. It also depends on what kind of a work we can get out of the AI. So very sophisticated work streams, like for example negotiations, I don't think the AI can help us with that. But I still feel that a lot of research work, initial drafting work, a lot of work, then endless hours that we spend on due diligence exercise, all of that will be well taken care of AI over a period of time. Of course, initially there may be certain issues or challenges, but I think over a period of time, AI is going to quickly learn and deliver a very good work product, particularly on those aspects where drafting is required or language is required or text is required. They are going to beat us humans in that. But wherever analytical skills are required, wherever negotiation is required, wherever argument is required, all those stuff would still be managed by humans. That basically means that the positions, particularly in the initial phases, okay, and associate level, that may get hampered. But a person who has the experience of handling the matters for the clients and navigate the entire transaction, that would still be very valid. Some of the other challenges is taxation, ESG, data privacy concerns. All these are new topics. We have to learn them. They are very important over a period of time. I can't even tell you, I was negotiating a long-term lease for a MNC client, and MNC client was asking me, let's put a clause on the lesser that, what are the emission norms, okay? How the polluted water is going to get discharged. Okay, I never thought that we would be supposed to add clauses relating to that in a particular lease deed. They were talking about carbon imprints, okay, on the environment for a particular developer. So these kind of clauses slowly and slowly will become very important in the larger scheme of things. Okay, a lot of time I think somebody also asked Rajiv that what kind of a skill set, and what should we do to become a good, say, arbitration lawyer or M&A lawyer. So these are some of the tips that you can have a look at. We'll be more than happy to discuss it. I tell you, it's just that, say, for example, from 2017 till 2022, I was also heading the internship committee for GSA Gurgaon office. And during that period, I used to meet a lot of this young kids' talent. Okay. And I was surprised and I was taken aback to see the quality of information or research they used to do before entering or stepping into the law firm. Okay. The kind of background information they used to have, the kind of research they did, the kind of articles they have written, the kind of extracurricular activities they have done. See, the point is, knowing the law, if you think that if you know the law, you have achieved something, I'm saying it's just a starting point. Means you are expected to know the law. In fact, what particularly the tier 1 law firms are looking at is going beyond the law. Means we expect you to know the law for sure, but we want to see what is that extra spark that you have to become a good corporate lawyer. And it could be anything. It could be personality. It could be how you meet and greet the person. Sometimes I receive emails for internships where they are writing to GSA, but they forget to even change the name of the law firm. I get an email that I want to intern with Luthra. And I'll be honest, that guy or that girl might be superb as far as knowledge is concerned, but please understand, we only have 2 minutes to read that email. Now you have to impress us in 2 minutes. You might be very good, and I'm not pointing on the caliber or the capability of the kid, but please understand, there are so many law firms, there are so many students doing the law. For us, segregating it becomes very difficult, okay? So yeah, means these are a few things, follow the trend, and I personally feel, and I'm just picking up what the honorable judge was speaking in the morning. Of course, you have a lot of opportunity. Means when I started doing law, we didn't have, let me call it, the luxury of so many other law firms writing on a particular topic. Okay, today, on any particular topic, if you go on Google, you will find so many articles. You know the entire concept before even working on it. We used to struggle. We never used to even get the drafts to work upon. Okay, now you have such a huge data bank. You have knowledge management team sitting with the law firm, particularly the tier 1 law firm. We used to, at least when I started, Manu Patra, he used to scan the judgments, and that scan used to miss at least 2-3 lines in between. So I used to read the judgment. I was like, this is not making sense. What is it? What are they trying to say? Then I used to go back to AIR, okay, to check it. But I'm saying still it was very good. At least I used to get some help from Manu Patra. Of course, they worked upon their shortcomings, and today Manu Patra is doing brilliantly well. Okay, but I'm saying it was still a help. Okay. And Mr. In my initial year when I worked with Mr. Jyoti Sagar, he used to tell me that, Karthik, you are lucky because you are getting a help from Manu Patra. And that time, and now I'm saying, Manu Patra, there were a lot of lacunas or shortcomings in Manu Patra at that time. So the time is changing. It's going to change for you also. I don't know how the legal world or the legal sector is going to look like after 10 years, but still, I am very optimistic. The transactions are going to grow, the laws are going to change, and we as lawyers are going to interpret and make sure that the companies are out of the risk, particularly from not going wrong on compliance and regulatory particularly. So with that, I close my session, but I'll be more than happy to answer any questions that you may have, be it relating to this topic or in general about legal field. I'll be more than happy to answer. Yes.
mentioned working with clients in Japan and with MNCs. How cross-border M&As are evolving in India currently?
They are not evolving. In fact, they have been there for last 25 years. You know, in 1991, when liberalization happened, I'm saying India is one country where the entire globe cannot resist but to come into India, because you see, geographically, we are best placed. Okay, from the population perspective, from the consumption side, okay, we are on the top. From the young people, okay, or the people in the age bracket of 20 to 35, okay, we are the best in the world. Of course, government is doing a lot of things to make the regulatory framework also, you know, on ease of doing business. Of course, a lot of things needs to be done, but a lot of things have been done in the past. So for the global MNC clients, okay, it's inevitable that they have to come into India and they have to invest. Okay, there's no doubt. But there are certain countries who really invest in other countries, and for example, Japan being one of them, UK, US, the entire European side. You now have a lot of companies coming into India from Australia side as well. But at the end of the day, it is very clear that the Indian run on the global forefront for business opportunity is going to be huge. Not right means right now also it's huge, but in next 5-10 years, India is actually going to come and outshine every other country. Yeah.
Hi, so thank you for the session. It was very interesting to hear all these terms all structured in such a comprehensive manner. So I have a question on dignitarization. I've been following the amendment ever since ever since Rule 9 was amended. And I remember back so when the deadline was September 2020, almost about 1,000 crore with some client, and then we could not get to the closing because we it's of dematerialization.
Yeah.
Extended the deadline to I believe June 2020.
Yeah.
Initially also that what would be the implications and are not going any possible that's going to fall on the companies. With respect to this, my question is how do lawyers like you have a better practical outlook towards how these transactions work and how these amendments have on an everyday basis. So how do we as M&A lawyers can contribute to such policy making? Because I think these two fields are seen as very distinctive by themselves. What would be your take on this?
Okay, that was a very long question and getting into 2-3 different things. Let me just tell you, as far as law, the framework is concerned and implementations is concerned, these are two different things. Okay. First, let's understand as far as the framework is concerned, it was done with a good intent. Okay. Whether it was implemented properly, of course, it's a debatable thing. To my mind, it was a chaos as far as implementation is concerned. Now let's understand why implementation was difficult. You know, India is a very, very big country. Okay. So let's understand. First, the dematerialization initially came for the listed entities way back. I'm talking about say 95 or say 2000. When they saw that, and then, you know, let me just tell you what kind of problems people used to face that time. When the shares were in physical form, there used to be a guy who bought a shares of MRF. Okay, I don't know if you have seen, and there is a reel, video reel around it. So there was a guy who bought shares of MRF when MRF was trading that time as a listed entity at hardly say 30 rupees or 40 rupees that time. Okay, and people used to feel in 1990s 30 to 40 rupees used to be a huge sum of money for a one share. Then he died. Okay, without telling his son that he bought so many shares of MRF at 30 rupees or 40 rupees. 20-30 years later, that guy was speaking to anchor on a Z News saying that, you know, I have so many shares and I recently found those number of shares in my father's trunk. Okay, and what should I do and how should I claim it? That shares were worth in 2008 or 9 worth 130 crore. So that's, you know, and imagine if that guy wouldn't have found those shares, physical shares in that truck, how can he claim that 130 crore? Okay. That is the problem that got solved by dematerialization of shares. Okay. There used to be so many dividends that companies used to declare and people were not claiming it. They didn't even know how to claim it. There were share certificates which got destroyed, defaced, they lost, they were not able to track them. That is the problem that dematerialization solved. Okay. Of course, there is a pain in implementation. I'm not doubting it, but that happened for listed entity. Okay, in 2000. Then the law came that all the public unlisted companies, they were supposed to get their shares dematerialized. That was the second step. Then, of course, private company happened. Last year. There are so many private limited companies in India. If you will go and run a check on MCA website, you will imagine and you will get to know that for NSDL, CDSL, just to manage that kind of a traffic, I don't even know before implementing or before coming up with that law, they consulted, bureaucrats consulted with NSDL or CDSL that are you able or will you be able to track or implement this kind of an exercise. So that was the challenge. From our perspective, it was a nightmare to close the deals during that time because all the investors wanted, there used to be a condition precedent in the transaction document on the target entity, please get your shares dematerialized, without realizing that the RTAs or the depository participants are not even responding for months. Okay. So of course there were challenges, but see, at the end of the day, government authorities, they also see, okay, where the pain point is. And that's the reason they came up with this extension. Okay. Of course, they have extended it to June. I am hoping now by June, we'll be able to close a lot of dematerialization issues, but I'm saying it's a step in the right direction, at least. Okay. Is it a, costly exercise? Yes. The foreign investors initially may feel that they are required to submit a lot of information, documents, and everything. But eventually, in the long run, it's going to benefit the sector. In fact, this also requires. I don't know if you have dematerialized or you have studied on this subject matter. But foreign investors are now actually supposed to take PAN before they get their shares dematerialized. So there are so many companies, foreign investing companies, they don't even have the PAN in India. First, they have to go and get the PAN to even get into the dematerialization. Then they have to trace all their share certificates, ensure they got stamped that time. It's a painful exercise. But I'm saying after 10 years, if they're trying to trace their shares, okay, and their eligibility, at least they will have a place to look at. Okay, any other questions? Yeah.
While the government liberalizes the norms, but also doing strict scrutiny, what would you, as a practice leader, recommend aspiring especially in a hybrid sector?
So if you can just repeat the question for everybody, means of course I heard the initial bit, but rest of the people didn't. But yes.
The recent the government will liberalize the norm, but also every what would you as a practice leader recommend us aspiring entrepreneurs to navigate such changes in the high growth?
In the
high growth sector.
High growth sector. Okay, see, these are two different things. Liberalization, as far as liberalization is concerned, I personally feel, yes, there are so many laws which should be liberalized, definitely over a period of time. If you will see, there are so many acts which got framed when Britishers were ruling India. Okay, so liberalization, change in law is something which is inevitable, which is going to happen. Liberalization is always better. As far as regulatory concerns are concerned, I personally feel they are regulating those areas which needs regulation. So, for example, if you will go overseas, you will find that overseas government, even for a small non-compliance of jumping the red light, they put a fine of 1 lakh rupees. Okay, till the time you don't have those kind of stringent laws or the penal consequences attached to it, people are going to take it in a very liberal sense, and they are going to breach sometimes. Okay, intentionally and unintentionally is different, but I'm saying the penalties attached to all the regulatory oversight of other countries, as far as that is concerned, that is much more than India. Okay. In India, you will never see any regulator putting a fine of say 500 crore, 1000 crore. But if you will go on European Union, you will see the kind of penalties they put on, say, companies like Google, Alphabet, Meta and all. So both the things are required. It depends where it is required and whether they are using that power in the right direction. So if somebody is using that power to take an advantage or to put some companies, only selected few, in a troubling position, that is wrong. Okay, but regulations regulating a particular sector, I don't think it's a wrong thing. From our perspective, we should be very cognizant, of making sure that we are not stepping over the line or we are not doing any non-compliance. So that is what we are supposed to do. Okay. So one more. Yes, please tell me.
So with regards to Indian promoters, especially in merger and acquisition deals, do you think they have certain apprehensions when it comes to diluting their holding in general when they open instances of foreign deals? Do you think there is an apprehension in Indian promoters thanks to their family relation and large book holdings that is majorly networks?
See, not exactly. Means this question is not very generic in nature. Means it depends on the family you're talking about, the promoter you're talking about. There are so many Indian promoter-run companies who have diluted their stakes over a period of time. But then you also have certain conservative family mindset. So let me give you an example. Also, say Haldiram. Haldiram was not ready to dilute their stake for so many years. Means I can't tell you, this is one business, and particularly I'm talking about the entire these snacks and savory food products that they sell. For last 20 years, they were not open for this idea to get some foreign investor, or for that matter, any investor outside the family setup. But recently, in fact, last month, they sold almost 10% stake to Temasek. Again, GSA only did that transaction and represented all the investors, but it was a very challenging deal. But the question that you have asked depends on what is the setup of that promoter, Indian promoter family. There can be multiple reasons. They might not be that time willing to get a third party on board, because whenever the third party comes on board, they come up with certain expectation. If they are investing 100 rupees, they will definitely expect to make 500 rupees and get out of the business. So Indian promoters may be wary of that particular issue. There could be others. Indian promoter family-run businesses, typically they like and they enjoy a lot of flexibility while operating. When you have a structured fund coming into the company, they may have a different mindset on, say, governance, on decision making. Okay, there could be on compliances. So it might not say gel that well with, say, certain Indian promoter and companies. It also depends on certain sectors. So for example, if you take a sector like real estate, the fact of the matter is it's still a cash driven sector. Foreign investors, they don't get into cash driven sectors typically. Okay, so there can be multiple reasons. Okay, yes, please.
When we are speaking about foreign investors, so they are used to a certain kinds of transactions in their jurisdiction. For example, in America and Singapore, there are statutory provisions for minority squeeze out, which is not there in India.
You have a minority squeeze out in India also, by the way, but yeah.
So how are we managing those expectations, and is the Indian government also taking cognizance of these expectations and making further changes?
Of course. So for example, let me give you an example. Say, let me start by saying minority squeeze out is still, as far as concept is concerned, it's there. If you will read starting from section 230 to 236, you will find multiple provisions dealing with minority squeeze out. The real question is it easy to implement it? Answer is no. Okay. But it also depends what kind of a company it is, whether it's a listed entity, unlisted entity. Say minority squeeze out for a private limited company is still okay to implement and comparatively easier. But the moment you get into, say, listed entity space, it becomes very very, very difficult. At the same time, whether Indian government is coming up with certain regulations which typically you see on a global platform? Answer is yes. Again, implementation is slightly challenging. You may see, for example, class suit actions. It was not finding its place earlier in the, as far as Indian legislation or Indian laws are concerned. Indian government is also coming up with certain relaxation and new structures which earlier were not there from the M&A perspective. So, for example, the cross-border share swap transactions was not permitted earlier. Okay, now it is. The reverse merger and reverse flipping and re-domiciling laws were not earlier there. Now they have done it. So I'm saying it's a matter of time. Yes, as far as governance is concerned, compliance is concerned, certain other countries are far way ahead of us. But we are also trying to catch up as soon as possible. Okay, done? Okay, thank you. Thanks, everybody. It was lovely taking this session.
Thank you, sir, for sharing your insights with us. It is truly an honor for us to have you here. The session has been immensely valuable for all of us, specifically people who are interested in pursuing M&A as their career. It is now an absolute privilege for me to introduce our next speaker, Ms. Surbhi Mehta, co-founder and partner at Adrit Legal.
She's a seasoned legal professional with over 20 years of experience heading the practice areas of intellectual property, competition law, trade, TMT, regulatory, and policy matters at the firm. Her practice is not only vast in scope, but also deeply impactful.
She has been at the forefront of major legal developments. Most notably, she was instrumental as counsel for the informant in landmark Google investigation. She has also led major assignments on IP due diligence, licensing, and franchising transactions, and monetization of IP platforms.
What sets her apart is her strong commitment to policy research and knowledge sharing. As a research analyst and resource faculty at the Indian Institute of Corporate Affairs, she has actively contributed to policy discussion on topics like competition and IP interface, WTO obligations, and interregulatory cooperation.
She continues to serve on panels of statutory industry associations, regulatory bodies, and PSUs, offering strategic counsel and thought leadership. In addition to her litigation and advisory work, she is also a prolific writer and speaker with published work on privacy, franchising, and sports law. And she's also a member of the International Bar Association.
Today, she will speak on the topic Competition Law in the Age of Digital Monopolies, Insights for Future Antitrust Professionals in India.
Please join us in extending a warm welcome to ma'am. Ma'am, the floor is all yours.
Thank you. Hi, my name is Surbhi Mehta. It's written right there. Okay, the topic that has been assigned to me is competition law in the age of digital monopolies. It's a very, very, very wide topic. I plan to make this session into an interactive session. I don't have a PPT to discuss the law. So we'll start with how many of you know a little bit about competition law? Quite a number of you. So I want, so just to ask you, why do you think we need competition law in the market? Not a test, just a process to run the conversation. Anybody who can answer me why we need competition law in any market? Yes.
Ensuring fair competition, fair compliance of all the laws. I think to ensure that there is no violation between the companies and they're not doing anything which is against good competitive behavior. I think that's where the competition law is.
So I'll take the last line to ensure that they are not doing anything which is against the competitor, or they're not doing anything anti-competitive. But what is something which is anti-competitive? Anybody who can give me, yes, please.
Anything that harms the interests of consumers, wherein there should be fairness in market, fairness in prices, so that opportunity is given, choice is given essentially, choice of consumer is protected. So the way I look at competition law is in relation to consumer law, where consumer is at the heart of everything.
Okay, that's a good perspective. So competition law is little bit more than just consumer welfare. So consumer welfare is inherently bred into competition law, but the main aspect of competition law is to ensure that the companies are not doing anything which is stifling competition in the market. Competition means the ability of any person, any company to come into the market when they want to, do the business the way they want to, of course, in the realms of regulatory laws. And nobody should be forcing them to do anything. Nobody should be forcing them how to or how or not to conduct the business. So competition law is effectively dealing with checking into that there should be fairness in the market for everybody. Now, when we talk about digital monopolies, the entire scenario changes. Digital monopolies are not like traditional, companies where the focus is on supply of goods, provision of services. They are a different league altogether. Now, I'll start with what do you mean by digital monopolies? What do you mean by digital monopolies? Yes, anybody? Yes. WhatsApp, etc. They monopolize on smart data to cater to markets, for example, Instagram. We say that the smart data to monopolize to cater to the artifacts which are the was. So let's talk about that's a very good answer. See, digital monopolies by definition, I would remove the word monopolies. Digital companies by definition is a company which is working in the digital space, offering services in the digital space. So as how she said, price is not always a relevant factor in that scenario. Unlike a traditional model where you will go that I want to purchase clothes, you'll go to a shop, pay money, get clothes. Digital companies don't work like that. How does Facebook work? You join Facebook, you don't have to pay a user fee. So they work on a different business model altogether, where you have some concepts like network effects coming into being. Network effects means something which is the more number of users are there which is using that digital monopoly, the better value you have, the better market presence you have, and the better market and the better dominant structure you have. So digital monopolies have certain characteristics which distinguish them from a traditional brick and mortar shop, brick and mortar services company, and etc. So these are network monopolies. They work in a highly specialized field. They have a lot of data which they can monopolize, which they can use. They have a lot of usage of artificial intelligence, and ultimately their market structure is not dependent on the amount of market share they have. So this is what is digital monopolies. Now, when we talk about competition law in the age of digital monopolies, we need to understand the regulation of competition law. The regulation of competition law under the Competition Act of 2002 is there's just 3 sections that you have to talk about. Anti-competitive agreements, abuse of dominant positions, and combinations, these 3 things. So, entire structure of how it is to be done, what are the factors, everything is included in the Act altogether. Now, why do we need a different structure? The first thing that do we need a different structure for digital monopolies to come into? That is something which the decisional practice of competition law has shown us. That when you have digital monopolies, they do not counter or cater to the factors which are given in section 19.3, 19.4, etc., etc. I don't have to teach you law, but they pose a lot of challenges, which challenges are a little difficult to maintain right now. Now, what is the traditional model of regulation of competition law? You have, sorry? Ex post, absolutely, I was coming to that. So you have so you know the difference between ex post analysis and ex ante analysis. So ex post analysis is when a violation or anything has already happened and then you are scrutinizing it. And ex ante would be when you are doing it before. So typical difference between 3-4 anti-competitive agreements and the regulation of market dominance and combination. Combination is ex ante. The other two are ex post. Now, if you apply that to digital monopolies, you would see that there have been many cases which have taken place where where the regulatory bodies have realized that ex post analysis may not be a very suitable thing for digital monopolies. So let's talk about the regulation part. We'll start with section 4 and present the views of dominant position, because digital monopolies by their very nature becomes monopoly very fast. You start with a Facebook, more and more number of users join it, it becomes a monopoly. And then when it becomes a monopoly, it starts doing exclusionary practices. So let's start with section 4. How do we deal with section 4? So you have what are the ingredients of section 4? Anybody? Yes. Absolutely. You guys know quite a bit about competition law. So, so as you said, relevant market. So the question is, the first challenge that comes into being is in terms of regulation or delineation of relevant market in any case. This is the basic thing which will make or break your case, because anybody informant would want the market to be as restrictive as possible, and the other side would want the market to be defined as broad as possible. Now, if you look at the traditional tools, the econometric tools that we use for competition law, we have those snip tests, if you know, the critical loss theory, analysis theory. So those may not actually be very particular for digital monopolies. Why? Why would they not be particular? Anybody who can answer me that question? Absolutely. So they may have high initial costs, but their variable cost is very negligible. So, so in terms of you move that, the definition of market, it was very difficult to ascertain, especially considering that they are providing you a non-price function. They are not taking any charges from you. Now, if the decisional practice of competition law has shown us that CCI has also taken its time in terms of finding out how relevant market assessment has to be done in the digital things. Initially you have all those Snapday cases where the relevant market was defined very restrictively. Then slowly you moved on to that Amazon Flipkart case where the relevant market has been defined very broadly. So all these evolution of the law has taken place. Then you come to the next step, which is the after assessment of the market, relevant market, you come to assessment of whether the company is a dominant player or not. You have these factors. Traditionally, market share has been the most important factor. Everybody says that market share is there. But if you look at digital monopolies, that may not be a very valid concern, because any company who has just come in, can just capture the share like that. So your assessment at a relevant time may not be proper, for us, because the effects of the anti-competitive effect will come at will start giving them profits 2 years or 3 years down the line. So digital, when you apply digital companies, the regulation of dominant structure itself needs a change. Then we come to the third step, which is whether they are abusing or not. Standard practice, dominance is not a bad thing. What is a bad thing is the abuse of dominant position. So there also, CCI has found a lot of challenges in terms of accepting what can be in abuse and what cannot be in abuse. So I'm not here to discuss the exact case laws. You must have done your competition law. So my topic is, what are the insights that are there for the future antitrust professions? So we move on from there. I'm just briefly touching all the competition topics. Now we move on to then section 3, which is anti-competitive agreements. So, like for example, you have those Make My Trip case where you have, I don't know whether you know about Make My Trip and Oyo case, where you have those exclusive arrangements between the Make My Trip. So all these things come into being. Then you come to combinations. Combinations, again, standard thing. Will take on from the mergers and acquisition where two companies are coming and joining together, and you have those deal value in it. Now, what do we learn from all this? What are the insights that you as lawyers who are entering into the profession need to do? One, you need to have excellent research skills. Any area of law, the research skills become standard. Now, as far as competition law is concerned, you need very specific research skills. You need to know about economics. There are specific econometric tools that you ought to be aware of, because as a future antitrust lawyer, you need to work with economists. You need to work with people of different fields. So research skills, networking skills, I will not repeat what Karthik has repeated to you. So insights that I can give you is in terms of, okay, do you have any questions in terms of what do you think where I should lead this? Yes, please. For compliance, yes, absolutely. See, 3 and 4 are like any other litigation practice. You have the practice for CCI itself is litigational practice. Then you move on to the appellate tribunal and to the Supreme Courts and all that. So there are a lot of law firms in the country which have specific departments who are only dealing with Section 3, Section 4 cases. So you can, in fact, most of the work that happens is in section 3 and 4 because the combination part of something is what mergers and acquisition takes place. So you have clear defined roles in terms of where your practice can be in terms of only in litigation or only in terms of combination. No, there are a lot of. Well, that's because combination, see, there's a difference between ex post and ex ante. The liabilities are different. There, the role is only to make sure that the deal happens, and that has to be a faster. There is much more obligation on the CCI for that. There, you are charging somebody for that. So you can find a process. So that's why it takes a little bit of a difference, but competition law is evolving day by day. From 2009, where there used to be like 5-6 cases, now every day in front of CCI around 10-15 cases are listed, maybe more some days. So I mean, yes, I don't agree with the fact that it's not happening. Well, actually, it's a very difficult question to answer because there are a lot of client dynamics that come into picture. Once you graduate from your law school, you'll realize that law practice is not just about doing your research and presenting your cases. There are a lot of client dynamics and stakes that are involved in the thing. But as a team which is representing. The senior advocate will only argue what you will brief it. So your role will come into being slowly and slowly as you move up in the seniority chain, you will get your chance to argue as well. If you want to argue, the best chances are to be a lawyer for the informant than the lawyer for the opposite party, because the lawyer for the opposite party, the stakes are very, very high. So not just one, you take 3, 4, 5 senior advocates in that. So, frankly, the focus should be more in terms of initially to get through the knowledge of it and then thereafter getting into that. Yes, please. That's a very good question. See, law in general, not just competition law, law in general cannot be isolated into one practice area. So when you have, let's say, a case of Google, so where you are dealing with search bias, so the opposite side can take up issue with respect to privacy. They can take up issue with respect to intellectual property. So you will have to understand all that. So no law can be read in isolation with respect to any other law. So you have to have knowledge of everything and then apply that knowledge into that specific field that you have. All right, now the questions. Now let's come back to the topic. So, see, the idea that I had for this thing was that I have to come and teach you about digital monopolies, but I can see that you guys are very well aware of everything. You want to discuss something about the new competition draft, digital competition bill that has come in? Okay, so you're aware of that. So unlike traditional models, when you come, the decisional practice of CCI has come and you've seen that it is difficult to apply the typical concepts of how to assess market dominance, what is an appreciable adverse effect on competition to digital field. So there have been amendments in 2024 last year where they have further enhanced these factors and try to make them best for the digital field. But it has been seen that if you have, the digital monopolies, they have issues of data monopolization. They have issues with respect to privacy. They have issues with respect to data control. So all these issues may not be dealt with by the typical traditional model. So there has been a committee which has been formed by the Government of India, and they have given the report, and this draft digital competition law bill has been passed. So there is a concept that has come into, which is an ex ante regulation. So they will come back now again to the market share, coming pulled back into the market share thing, where the government will identify certain factors, and on the basis of that, they will say that there are some substantial digital monopolies, significant and substantial digital monopolies, which have to get into the ex ante regulatory aspect. So why do you think are we taking a U-turn and going back to the MRTP model where we are only focusing on market share and not anything? Do you guys think that? No, but EU is not just on market share. There are a lot of well, you can say that, but yes, please.
They will give to the Indian market. Something like the PCB is very important in India. As far as the comparison that you have with the Indian market, the comparison you get, yes, one question that we did have is, quite definitely agree that they are not simply looking at market share. They are looking at price factors, that's what matters. But the fact that most of it is delegated to central regulations based on reason. You know, this will raise a lot of compliance costs now because now you have legislation that will be part of that market. But an increasing trend of sort of regulations coming out towards substantive rights of obligations of all the market players. But there is constantly a flux of more of a regulation come out that might change our dynamic. This is really important. It's something which means good. But over this over delegation of subordinate legislation might be bad. Very different.
Okay, 2-3 very different questions. But first of all, let me tell you, it's not going to be in the nature of a subordinate delegation. It has to come in the nature of an act in itself. Otherwise, it will not be viable. Okay, yes. No, again, coming back to that only. That has to come by in the form an act in itself. It cannot be in the form of a subordinate legislation. Only procedure, not substantive. By law, it cannot be substantive things, cannot be dealt by subordinate legislations. Only procedure, maybe a specific value of deal value, like you have in the combinations thing, where you, by means of subordinate legislation, you can keep increasing or decreasing the deal value. But all these factors, who are these SSDEs? How will you determine whether it's SSDEs? What are the kind of ex ante regulatory practices or compliances that they have to follow? They'll all come by in the nature of an act, not in the form of a subordinate legislation. But coming to your other aspect, I agree with you that since it's not just market share, it's also non-price. It's a much wider and broader topic to deal with. But my question is a little different. My question is in terms of since we principally, because non-price factor are a little difficult to ascertain. So principally, we will determine in terms of the market share right now or the potential market share that you have. So don't you think we will go back and taking a U-turn and going back to the MRTP thing of saying if you are big, you are bad? Well, you have the answer. So data control is what will determine your market. It's not the market share. It will determine your market influence. Like you have that Google case where, the search bias case or the self-preferencing case. What exactly? This is all an aspect of that, where you have a dominance in one particular restrictive marketplace, and then you are using that dominance into another new entrant field. So to take that into consideration. Any other question you have in terms of insights for future antitrust professionals? Yes. Competition law and taxation law. Combinations to an extent, yes. because you'll have to determine in terms of how it like affects taxation angle. But no, I think the two law operate in different fields. Not really.
And we have judgment about happening almost daily from NCLAD and CCI. How will it affect future? Because I was just expecting something to happen.
So it's a new law, it'll be a new law altogether. It's going to make the field much more interesting. It's going to make the field much more evolved in terms of, like when we had the new competition law that came into being, we already had MRTP Act. So we took principles from MRTP Act to interpret the new competition law. So similarly, the new act that is going to come, we will take principles from the competition law to interpret the new competition act.
Especially considering the huge population and the data collection problem that we have, especially in the technical level, we have a lot of cyber.
Implementation will completely be different. We have different culture. We have different practices. Our privacy law at present are not at the same level as that of the EU law. So implementation is going to be a complete different ballgame altogether. Even in terms of you take all these principles from EU, bulk of our competition law is derived from EU. So you take all these principles, but then the market dynamics in our country is different. Where, let's say a bid rigging thing, where I may not be a part of a cartel, but historically I have seen that these two big companies set the price and I just have to put 1 rupee less than that. Or I have to put the same price like that. That's not bid rigging, it's a different culture. So those cultural differences do come into practice and the law will evolve accordingly. No problem. See, ultimately, all laws are territorial in nature. So, if there are cross-border transactions which may have implications in India, the Indian law will determine on the basis of the dynamics that we have here. The cross-border transactions operate on a different level because there the whole idea is to check whether you have an appreciable adverse effect in competition on the basis of the factors listed now or new factors which will come into being with the new act. So that is just to ensure that the market, no monopoly is being created so that they do not have the ability to put anti-competitive things on others. Your question is little different. When you look at the things which have already, an act which is already taken into place and you are figuring out the liability aspect of it, that will take a little different place than an ex ante regulation. Yes, please.
Unlike it's a regulation of the different things that how would you deal with clients telling them what could be violations? Definitions and what is the
that is going to be a job profile for the rest of your life the moment you graduate. See, the past decisional practice always serve as a guide in terms of how the things are going to be. When you talk about combinations, again, as I just told her, combinations work in a different domain. Section 3 and 4 work in a different domain. 3 and 4 act has already happened and you are checking. You need to have evidence that appreciable adverse effect has happened or there has been abuse of dominant position. Whereas when you look at combination, it is likely to have an appreciable adverse effect. So that likely can be very speculative also. So different things are read into it, that don't do your deal like that, don't do your deal like that. So completely different aspects. So your job as a lawyer will be to analyze all these different decisional practice and then apply your into the facts of your case and then give a advice to your client accordingly. Frankly, this is the role of the lawyer for the rest of your life, not just in competition law, in any other aspect of law. Your client will pay you for your analytical skills, whether you'll be able to assess what can a judge do. Let's say if your client has done something wrong and you're presenting a argument in front of the judge. So your ability to foresee how a judge will interpret it and take a decision is going to be your Brahmastra, I'll say, and that is something which you should be working upon. If you have that ability, the analytical ability, any lawyer, any law firm will just hire you like that, because that is what law practice is all about. Yes, please.
So, ma'am, I was researching on the AI and governance practices, whatever that is being proposed by the government. So I noticed that the Ministry of Electronics and IT, they suggested a AI governance guidelines report wherein they suggested a whole of government approach. So basically combining certain professionals from SEBI, RBI, CCI, etc. All of those will look for AI regulation collectively. However, the draft digital competition bill, it talks about the regulation only from the perspective of competition. So I think there is a sort of a disbalance between what the government is proposing for the regulation of AI, and Suraj, I just wanted to ask what can be anticipated as the future here.
See, AI is a very wide field. So it's like a subject area. So when you look at a subject area, there are multiple, as I said, law can be read in isolation. So a given fact situation will have implications on criminal law, civil law, intellectual property law, competition law, maybe mergers and acquisitions and everything. So then what the AI thing is happening is for them to assess what are the different laws that can regulate, that can have an effect on them, and then with an idea to regulate them. That's why you have SEBI, you will have any market regulator, ICI, I'm sure will come into being, and this NAFRA will come into being to give their perspective of how to do regulations. But when you look at CCI, it's a specialized act. Its job is only to regulate competition in the market. It may have effects on intellectual property or any other law, but that's not his job. There have been cases in, about standard essential patents cases in CCI. So when CCI is looking at it, it's only looking at it from the perspective of competition law, how it is affecting the market. But when you compare it to whether it's a patent which could have been given or which couldn't have been, whether it's an exception or it was already in the public domain, that comes under the domain of patent office, intellectual property office. So different fields altogether. But as a lawyer, your ability to read that and apply that into the competition field is what will distinguish you from any other person. Because if there have been so many cases where I was representing a DDA, Delhi Development Authority, in a competition law matter, where some investigation was started against us. And the ability for me to come back, say that competition law doesn't even apply to me because I am under regulation of somebody else, the DDA regulations. So, all these things you have to keep in mind to give the best possible advice to your client. Yes, please. Okay, different fields. But see, the competition law, when the draft competition law, the idea is to ensure that you have privacy issues, the data control issues, data monopolization issues to come into being. And how the role of competition law is only to assess whether all these aspects are giving you market power, so that when you have the market power, you are either abusing it or you are forcing somebody to get into exclusionary or predatory agreements with them. The competition law's job is there. Consumer welfare is read into them only to the aspect that when you, let's for example, when you are a company is a dominant company, it's abusing its dominant and it's forcing its vendor to get into an agreement with that. Let's say to ensure that the prices remain high. So who's getting affected in all that? The company is making profit, the vendor is making profit. Who's getting affected in that? The consumer. So consumer welfare is read into competition law only from the perspective of that it ultimately it's the consumer that has to pay. To that extent, privacy issues are also read into that. That ultimately, in terms of when you are dealing with competition law, you are not affecting somebody's privacy rights, or you are forcing somebody to give up their privacy right. Like, there is a debate that happens that long back there used to be this concept called shrink wrap agreements. I don't know whether you're aware of that. So the shrink wrap agreements are something which you, let's say you want to enter into a website and there are terms and conditions that come into being. Till the time you don't check onto that, you don't move ahead. So those are, so you don't have a choice. You want to use that, you have to agree to that, right? So, so all these, so only to that extent that whether they are stiffly your right to be the market, the competition law will look into that. The Data Privacy Act's job is different. It's to ensure that nobody is taking your information without your consent. So consent is the biggest factor there. Different field. So it will be more of an unfair trade thing. Now that will again come into the, at present it will come into the consumer law domain, where you can file a case stating that it's an unfair term, and I will not be party to that. Once the DPP Act comes into being, you will have another specialized tribunal who will going to be looking into it. So the whole aspect in your question was on the basis of consent, whether the informed consent was taken from me. So that aspect will look into the data privacy tribunal, but competition law will only look at it from the perspective that whether you are letting other people enter the market, you are not creating, you're not stifling competition or stifling innovation to that extent. Yes, please.
Strategies as the data strategies across borders, and that would definitely have right? What's your take on that? How do you determine if the data currency across borders can be undefined?
So that is what data monopolization and data control issues that arises. So the acceptance of data as a competitive asset, like for example, you have that Android case, the CCI. So in the Android, sorry, not the Android case, the Facebook, WhatsApp case, the privacy part of it. That was the first time where privacy, whether or not you're taking informed consent or not, was understood to be a relevant factor in determining your market, the dominant position in the market. So all these aspects will be factored into certain factors which will determine your market share, your dominance in the market. Coming back to that, it will not come into the concept of whether informed consent was taken or not. Only from the perspective that because you have so much of data of people, you can use that data to get into some other market. You can use that data to give them differential price. You can use that data to probably sell that data or give that data to your related companies at the exclusion of somebody else. That factor is what competition law will decide. Yes.
National market, if I may. So, in the aviation sector, there's Boeing and Airbus who have recently acquired the smaller aircraft manufacturers. So, effectively, in academic literature, Boeing and Airbus are referred to as duopolies or oligopolies in economic terms. These two big market players hold more than 90% of the aircraft manufacturing sector, which would in fact lead to a lot of antitrust issues. But there is no international antitrust aviation law that regulates this sector. So I wanted to know your opinion on how future young lawyers who want to deal with antitrust law could tap into the international market where antitrust issues do exist, specifically to aviation or more so into any other field. But antitrust law does not exist.
There will be very few countries where antitrust law do not exist. They will have their own practices. Like, for example, before we had the Competition Act, there was an MRTP Act. Before there was an MRTP Act, you could take them under contract law, in terms of, so different places will have different ways to tackle such a situation. But the kind of world that we live in, it will be very difficult to believe that we have a country which do not have antitrust law into being. They may not have a specialized law with respect to aviation itself, but that's a very well thought process because this regulatory challenges that come into being, like we have the standard essential patents case where the regulation of competition laws or exclusionary issues with respect to patent has been given in the Patents Act. So now, but that doesn't mean that competition authority cannot look into it. So, so what has been happening is that the governments of every country, I can only talk about India. What has been happening of late is that the specialized regulation of competition is being taken away from the sectoral regulator and moved into the under the competition authority because they are the specialized agency for that. Sectoral regulator works in different field. The purpose is different. The purpose, like in patents, the purpose is only to ensure whether I should give you a patent, I should not give you a patent. The focus is not in terms of whether you can use that patent to create exclusionary conduct in the market, or whether that patent, I may be a small company today, but I have a research which will create a new anti-cancer drug. So today I don't have a market share, but the moment I launch that drug, my market dominance is going to become so big, market influence is going to be so big that I can try and create exclusionary conduct for others. I can tell the other pharma companies, do not deal with other. You not only buy this cancer drug from me, you also buy my other drugs. So that aspect, a sectoral regulator will not have neither the ability nor the resources to look into it. So coming back to your specific question, so any regulator, like aviation, we have an aviation regulator in the country. So aviation regulator also looks at certain exclusionary conducts, but only from the perspective of regulating the eviction market, whether consumers are getting affected, whether you are not doing anything from safety perspective and all that. But not from the perspective that it is stifling competition in the market. That only comes into the domain of competition, Commission of India. Like for example, we had this case of differential pricing by airlines. Where same ticket, you'll open the computer, it will offer you 5,000 rupees. And if you'll open it, will offer you 7,000. That is determinant on your data, on your ability to spend. So there are crawlers available. Any digital company will see that your ability to do online purchase is much on a higher level than your ability. You only buy t-shirts for 2,000 rupees, but she buys t-shirts for 10,000, 12,000. So she's going to get a ticket price which will be much higher than yours. So is that stifling competition in the market, or will it come in only in the consumer welfare department? So all aspects dealt by competition authorities or antitrust authorities. The problem. Yes, anybody else? All right. Any questions? No questions. All right. So let's come back to the topic itself. So I don't want to teach you about competition law. I don't want to tell you what are digital monopolies, what are that. You guys know it altogether. A future antitrust professional should know, should have his basics very clear in terms of economics, in terms of your law, and should have the ability to analyze those and read that into competition law. If you have the ability to analyze, and if you have the ability to bring that into the facts of your case, this is what is going to make you or break you as a professional in the country. Not just in the field of competition law, but in any other field altogether. This will be my 2 cents for the day. Thank you.
Breaking for lunch now. We'll have Asthana and Sifan and the panel discussion in the conference hall. We'll have someone guide you to the MPH where the lunch is at.
All right. No problem. Sure.
Everyone will be breaking for lunch now. The next speaker will be speaking in the conference hall. The next event will start at around 2:50.